the Royal Commission into Violence, Abuse, Neglect and Exploitation of People with Disability is now in session.
Good morning to everyone who is following these proceedings. This is the fifth hearing day of the Royal Commission's Public Hearing 27, which is investigating conditions in detention in the criminal justice system for people with disability. For those of you who have been following the proceedings, you will know that we had intended to have 5 hearing days in Perth. One of those hearing days could not go ahead because of the public holiday following the death of Queen Elizabeth II. Today we will have the 5th day of the hearing, and this will provide an opportunity to hear from representatives of the state of Western Australia. It's not practicable, or it has not been practicable for us to continue the hearing for one day in Perth, and so this hearing will be conducted remotely. Commissioners Mason and McEwen are in Adelaide for the purposes of this hearing. I am located in Sydney. Mr. Griffin, SC, Senior Counsel assisting the Royal Commission, is located in Sydney as well. I shall now invite Commissioner Mason to make the acknowledgement of country.
Thank you, Chair. Kaya, we acknowledge the Gadigal people of the Eora Nation as the original inhabitants and traditional owners of the lands on which we gather today. Their lands are where the city of Sydney is situated. We acknowledge their ongoing spiritual and cultural connection to country. We acknowledge the Kaurna people of Tanya Wama, where the city of Adelaide is now located. And we acknowledge the Whadjuk Noongar people. Their lands are where the city of Perth is situated. We pay our deep respect to First Nations people here today and who are following this public hearing online on the mainland and on islands, including the Torres Strait, especially elders, parents and young people with disability. We recognise all First Nations people and acknowledge their enduring connection to land, sky, seas and waterways. Thank you, Chair.
Thank you, Commissioner Mason. Yes, Mr. Griffin.
Commissioners, before I call the first witness today, can I make a brief opening in relation to an announcement made by the Honourable Bill Johnson, MLA, Minister for Mines, Petroleum, Energy, Corrective Services and Industrial Relations for the State of New South Wales on last Tuesday, the 4th of October. State of Western Australia, I should say. Made last Tuesday, the 4th of October. The release from the Minister indicates the Western Australian Government to review young offender laws, and it says, Department of Justice instructed to review Young Offenders Act 1994, the review to consider the Act's objectives in current youth justice environment. Stakeholder consultation will help underpin examination of the laws. It then goes on to say as follows. The Western Australian Government will undertake a comprehensive review of youth offender laws to ensure they can provide the best outcomes for young people involved in the justice system and the community. Corrective Services Minister Bill Johnson has instructed the Department of Justice to determine whether the Young Offenders Act 1994 is continuing to efficiently achieve its objectives regarding contemporary youth justice issues and trends. Key principles of the Act include diverting young people from the formal criminal justice system where possible and using detention as a last resort while protecting the community. The review comes as the state's corrective services, police force and courts face and adapt to a changing youth justice landscape. It will examine the overrepresentation of young Aboriginal people in detention, the effect of cognitive impairment, disability on diversion, and the isolation and separation of detainees. A consultation process will be undertaken as part of the review, an issues paper will be circulated seeking feedback from stakeholders on diversion methods, rehabilitation, and reintegration into the community. Written submissions received in response to the paper will inform the review, which is expected to be completed in the next 12 months. The Minister went on to say, youth justice is a highly complex area involving extremely challenging young people who have committed crimes or are at risk of doing so, and in many cases they need help to get back on the right path. Young Aboriginal people make up a disproportionate number of young offenders and young people in detention, which will be considered in the course of the review. Few would argue against the need for greater diversionary and rehabilitative measures for Western Australia's youth and addressing the overrepresentation of Aboriginal people in the justice system. He concludes the review aligns with the McGowan's government's priority of reducing youth offending. Commissioners, Council assisting you in this inquiry are pleased with the announcement by the Minister. It seems to pick up many of the issues we were canvassing in the public hearing in Perth over the first 4 days. We have a particular interest in receiving a copy of the issues paper, in being informed as to who will conduct the review and the degree to which it's independent of the department, and particularly of these precise terms of reference of the review. If those with leave to appear on behalf of the State of Western Australia are able in the short term to provide any information in respect to those issues, it would be appreciated. Can I now move to the witnesses? And I call Dr. Joy Rowland to give evidence. And can I indicate Dr. Rowland has already made an oath?
Thank you. Dr. Rowland, good morning, and thank you for coming to the Royal Commission remotely, as it were, in order to give evidence today. Just to explain, if you're not already aware where everybody is, Commissioner Mason and Commissioner McEwen are joining this hearing remotely from Adelaide. I am in the Sydney hearing room of the Royal Commission, and Mr. Griffin, who will ask you some questions shortly, is also in the Sydney room. You, of course, are in Perth, so we're in 3 separate locations, which is not unusual for this Royal Commission. I understand you've taken the oath, so I will now ask Mr. Griffin to ask you some questions. Thank you.
Commissioners and people with leave to appear in this inquiry can indicate Dr. Rowland has provided a statement for this public hearing dated the 9th of September 2022, which bears the identifier STAT.0616.0001.001. This statement can be found in Hearing Bundle C1 at tab 48. Attachment JR1 contains her response to the notice to give information number WA-MTD-0020. The attachments to the notice to give information are at tabs 49 to 59 in Hearing Bundle C1. Dr. Rowland, are you the Director of Medical Services for the Department of Corrections in Western Australia, and have you held that role since April 2018?
Yes, I am, and I have.
So you've been in that position for approximately 4.5 years?
I was also acting in that position and job sharing in that position prior to 2018. It's a variable time since 2013.
You're a general practitioner with a degree of specialisation and a particular interest in mental health?
Yes.
And you've had extensive experience in the Aboriginal health system in Western Australia?
Yes, I have.
Can you indicate the nature of that experience and any observations you've made?
Yeah, so my experience with Indigenous health began prior to doing my medical degree because of my family background and history. But since qualifying, I have worked in rural areas as much as I possibly could. And I've worked with Aboriginal medical services, including in Bega in Kalgoorlie, Grams in Geraldton, Warakamaya in Horse Creek, Obars in Kununurra, Brahms in Broome, and Port Hedland. Yeah. And I've worked in WACS hospitals, which have a high number of patients from Indigenous backgrounds. I've worked in Fitzroy Valley Health Service, which had a very active partnership with the Nindalingari Cultural Health Service from 1999 to 2007, and worked extensively with Nindalingari in setting up a partnership and co-locating our services. So that's just some of my experience.
Can I take you to paragraph 23 of your statement?
Yes.
You indicate there that pre-sentence reports are not accessible to health services due to section 22(4) of the Sentencing Act 1995, Western Australia. That section says a written pre-sentence report must not be given to anyone other than the court by or for which it was ordered, and the CEO of Corrections. You see that? Are you aware of that section of the Act?
Yes, I am. I've looked at the Sentencing Act and also read some state solicitors' advice regarding the Sentencing Act that our Director of Health Services sought in 2014. We've actually made some progress in this area since I wrote my statement.
Well, before you go on to that, can I just ask you one question? I take it you're not a lawyer by training.
No.
Section 22(4) small a says, and I quote, the CEO Corrections may use the information in a pre-sentence report to assist with the management of the convicted or sentenced offender to whom the report relates. Have you received any advice as to whether or not that new section, 22 small a, would enable such information in a report to be provided to you and others?
Yes, so that section was used since 2014 to provide limited access to sections of pre-sentence court reports to various parts of the department, but free and unlimited access hadn't been provided to health services. I have found out in the last couple of days in some conversations with other providers in the department that approximately 18 months ago, there was a decision made in court where an additional sentence is added to the pre-sentence court reports stating that access is, unless otherwise stated, access is available, and apparently this has enabled freer access within our department. And our Director of Health Services is putting now an application through for health services to have that same access through our record system. So we may have resolved this issue.
So to that extent, your statement doesn't reflect the current situation, is that right?
I think we've managed to make significant improvement since I wrote that statement, but there could be further improvement made because accessing the contents of a pre-sentence court report through a record system is somewhat clunky. And a component of the pre-sentence court report, which is the neurocognitive assessment, which is frequently done, is of itself a standalone medical assessment and could be included in our results, same as an X-ray or MRI or blood test. It could be included within our medical system, embedded as a result, and much more readily available to staff to refer to.
When I read the Sentencing Act, Dr. Rowland, it seemed to me that section 22(4) small a, when it says assist with the management of the person, could be read to mean that management would include the health services you're endeavouring to provide to inmates and detainees. Is that the gist of the change you've just described?
Yes, so include for our ability to use management is whether or not an excerpt of the pre-sentence report or that neurocognitive report specifically could be directly embedded in our medical record system as an additional information.
And that's important because frequently specialist expert reports are prepared for the court, and those reports, or a summary of those reports, appears in the pre-sentence report. That's correct, isn't it?
That's exactly the problem, yes.
And previously, your health service was being deprived of that very important information in the work you had to do.
Yes, we didn't have ready access to just review what had been done in neurocognitive reports and completion of, say, for example, NDIS applications, or understanding what an individual's challenges were so we could best work with them was not as straightforward as it potentially is going to be with these improvements.
And one of the difficulties you had, as I understand it, was that if you wanted to obtain a private specialist report, there was a considerable cost involved.
Yes, and additionally, if you consider it from the point of view of the person, those assessments are time-consuming and quite tiring. They sometimes are done across a couple of sessions which can involve different allied health professionals. So asking someone to undergo that process repetitively would be unfair for them, as well as it being expensive and or time, taking considerable time to arrange.
And am I correct in understanding that if you wanted to get the report done at public expense, that there was a considerable delay in obtaining the services of a specialist to undertake that task?
Yes, it used to not be available in the public system. There is now a public referral pathway, but the demand in the community is, as I understand it, still outstripping the supply.
So if there was a young person today in Banksia Detention Centre and you or your team decided that you required a specialist report, how long would they have to wait if it was done through the public system?
I would have to ring them today to find out what their current wait list is today. But the last time that I rang and inquired, the wait was anticipated to be about 18 months. But wait lists in the public health system can be quite dynamic. So I wouldn't want to state that is current wait list today without ringing the hospital.
Now, in the case of Banksia, a very high percentage at any one time of detainees are on remand. Is that your understanding?
Yes.
Presumably, very few would be on remand for a period of 18 months.
True.
So if there's an 18-month wait list for a public specialist report, presumably you wouldn't even bother going down that path in relation to a remandee because they would be out of the system potentially before the report could be assessed and conducted.
I disagree with that because we don't consider that only things that we can achieve completely are worth starting, and they would remain on that wait list and their appointment would still appear over that period of time. And whether that benefited them in the community or whether it benefited us, it would still be a benefit to their health. So we often write referrals for services that the person is very likely to be in the community at the time they'll receive. It's ensuring that continuity of care and communication so that they stay on that wait list and they get that service.
So if a notional detainee in Banksia today had a report ordered via the public system and they were released in 3 months' time, who would follow up to try and ensure they undertook the assessment when the 18-month period came around?
So continuity of care on return to community can be complex. If the person is a stable place of accommodation and they regularly see a primary healthcare provider, then our discharge letter and communication to that primary healthcare provider should be sufficient. And if the person and their guardian understood as well, then they could follow that up in the community. Very similar to if someone's at Paws Creek and you refer them and then they move to Kununurra or Broome, there's still the need for good communication and coordination. But notifying their primary healthcare provider of their choice at the time of discharge that there's a pending referral and ensuring the person understands is part of the process.
So firstly, upon release, there would be a discharge letter, is that correct?
Yes, so we have and there's a copy, I believe, of that discharge letter in the folder. There is a standard discharge letter which is generated from the medical record and has staff can also add additional information onto that. We also seek to proactively obtain consent from the patient so that if in the event that the hospital sends us the appointment, believing that they're still in custody, but they've now moved to the community, we obtain consent to provide the hospital with their last known address that we have on our records, so that we can ensure that person, even though they're now in the community, receives that appointment.
So at that point, would the primary responsibility rest with the released youth and their primary health provider in the community?
So if they provide us with a primary healthcare provider and we've sent that information to them, yes, then we have to assume that they will follow that up. We don't have an ongoing ability to provide care to them.
If they don't provide the name of a primary health provider upon release, do you then have any obligation to follow up with them directly?
Not in regards to outstanding appointments, but the patients can also notify the public health system of their current address, and there's a phone number and an email address that they can use for that, which we can provide to them to say, if you change your address, contact them on these numbers. Of course, a lot of the people that come in and out of custody find navigation of health systems complex anyway, and that we know that there's a relatively poor history of appropriate use of health services prior to coming into custody, and thus may face the same challenges in navigation on release. So preferably there is a care coordinator, such as a primary healthcare provider. We often, if they are unable to name a primary healthcare provider, will suggest some potential primary healthcare providers in the area in which they reside, or recommend, for example, that they ask their family who they trust and you know, find that information prior to discharge so we can assist them. A printed copy of the discharge letter is also included in patient property. They may take that with them to their provider of their choice.
Dr. Olin, you've preempted my next question. It seems that if a released young person doesn't have a primary health provider, the chances of them following up for that specialist assessment would appear to be slim. Is that a fair inference?
It can be challenging, but a lot of the children that come into detention, if we're particularly talking about detainees, have additional care coordinators, such as they're already under the Department of Community Child Protection, or and they have their justice community officers who will also assist them in accessing appropriate services and will often be aware that they need follow-up services. So it isn't as thin and vulnerable as it may sound.
Might the chances of them following up for that expert assessment be increased if community-based organisations had more access to Banksia, so they would be aware of all of these developments before the young person was released and could take some responsibility for following up?
Whether that point of transition occurs at the point that they return to community with those letters and phone calls and etc., as I've discussed, or whether you try to make more of it occur the week or two before they leave, there's still a point of transition and you still need good communication. And a lot of the people that are in detention, even in custody, don't live at the place where the facility is. So, for example, if they live in Kununurra, then OVARS or the primary health provider in Kununurra is not able to visit them in Banksia Hill or visit them in Derby Prison because of the distance. So I think the system that is flexible, no matter who they choose as their primary provider, and we optimise that communication for that period of transition. And I've known nurses to actually help patients book an appointment before they leave us, particularly if they're on medication, so that they've got an appointment with that provider on release. I think that system is more flexible for a range of providers than assuming the external provider can come in and visit as an external visitor. It would be, I think that would be far more complex.
Why? Why would that be less preferable to what you've just explained?
Because of a population in a centre, there would be multiple primary healthcare providers they might choose to use on return to the community. So, there may be 20 different community providers that are the choice of the people in detention, and to contact 20 different providers and ask them to come and visit the prison to make contact prior to release becomes complex, versus ensuring that those providers receive letters and information. It's quite likely a lot of those primary providers wouldn't be able to provide that service of coming in and seeing them prior to release. And if you had only a single external provider coming in, then you are minimising the choice of the individual and dictating who they see, versus allowing them choice and flexibility.
If the young person had not been previously the subject of an expert assessment, is another factor that upon release they may not be aware of how important it was for them to undergo such an assessment.
It's obviously a component of noticing that someone has an impairment in cognitive functioning, that there is an impairment in their cognitive functioning. And if there's an impairment in memory, or impairment in executive functioning, or impairment in attention, or impairment in decision-making processing, then it's follows on naturally that they're less likely to be able to navigate the system than someone who doesn't. So this is, as I mentioned, a lot of the people in detention have other care providers and guardians, parents, etc., who are also able to assist them in navigating that system. We wouldn't expect a impaired youth to take personal responsibility for arranging their own transport, etc., to an appointment. You would assume this, you would assist in putting that support in place, and that an adult guardian or some other responsible person was aware. But we do have, regardless of which service we're referring them to, versus be it neurocognitive, cardiology, ENT, etc., we do know that the DNA rate and the non-attendance for people in the community of appointments that have been arranged is likely high, and it's likely high even if they're not in detention. So a lot of people who come to us have a history of non-attendance at specialist appointments, even whilst they're in freedom, even for referrals that were made for them by their community provider whilst they were in the community. It's the nature of the people that end up in trouble with the law, is they also often have had difficulty attending appointments and navigating health systems and navigating justice systems. So we inherit people who find that challenging, and they may still find it challenging on release, but as best as we can, we put in additional supports for them.
Just for clarity, Dr. Rowland, DNA in that context is did not attend?
Yes, sorry. Yes, did not attend.
I'm still troubled, Doctor, by those that don't nominate a health provider, but clearly need, in your view, or the view of your team, such an assessment, that no particular person is given the responsibility to follow up upon release. Is that a gap in the system you describe?
As I indicate, there are several people who would generally be supporting most of the detainees. So it would be unusual for a detainee, and I'm trying to imagine the situation in which it would occur, in which they would be leaving with the sole responsibility to take care of themselves without there being someone else involved, or without there being a nominated clinic that they have said they would like to attend. So,
but Doctor,
that have to give further thought to which other scenarios and which other direct links and which community service would be appropriate for a statewide service to a public system. And I think the fact that a lot of the children are getting pre-sentence court reports done, and if we can improve our access to the work that's already been done, is a much simpler process is to ensure we have access to reports that are done and look at a fast track system to obtain those reports, rather than resolving the potential fines of a long wait list.
Could the practitioner to whom the referral is made, even though there's a long wait period, or the organisation to whom the referral is made, be given the details of the person and responsibility to follow up when time becomes available?
Well, the referral contains the details of the individual, and typically the booking clerks will make an appointment. That appointment will be sent to the address provided on the referral. And I indicated already some of the ways in which we try to ensure that if that address is changed, that we have consent to provide it and or the person provides it themselves. If that appointment is returned to the clinic, they will usually contact us and ask if we've got any way of contacting them, or they will be, if the appointment is received or the clinic believes it's received, but the person doesn't attend, some clinics have a one strike and you don't get a repeat appointment. Some other clinics have offer a second, offer a third appointment before they take them off the list. It depends on the individual rules of individual specialist clinic. So for some people, they will get a repeat appointment made, which will also be received out as a second chance to attend.
Dr.
So in terms of otherwise, personally follow it for the public health system to go further in finding people who have not attended at their clinics would be a question for the Public Health Service and the Department of Health.
And just to finish this topic, are you aware of any data which would tell us what I might call the attrition rate? How many people are referred for an expert assessment, but for one reason or another, that assessment never occurs?
No, I don't have the data on it. It would across specialties, the longer the wait list, the longer the attrition would be a typical scenario. And if the person who was referred couldn't remember or didn't understand the importance of attending, then the attrition rate is higher. People who have pain and are more likely to attend the orthopaedic appointment than someone who has a silent, painless condition, for example.
But some of these specialist assessments, if done privately, currently cost between $6,000 and $8,000, don't they?
They are the sorts of costs quoted to me recently. At the time I prepared the report, I rang for updated costs, yes.
And in your experience of the typical detainee at Banksia, they or their families would be unlikely to be able to come up with that amount of money for a private assessment. Is that correct?
Yes, now there is Medicare. There is a Medicare rebate they can apply for, but it's not a large percentage of that cost from memory. But there's a significant number are done through pre-sentence court reports, which is then therefore paid for by the public.
There's a certain irony, Dr. Rowland, in someone getting the assessment they need because they're in the criminal justice system.
Yes, and the implication there being that the criminal justice system is the catch-all for community failure, and that if the issues were resolved in the community, that we could bypass and proactively prevent them ending up in detention. Yes.
Based on your experience, Doctor, do you know whether the NDIS would cover the cost of an assessment if the person was a participant in that scheme?
Catch-22, chicken and egg, a little bit there, because to be enrolled in the NDIS, they first need to meet the criteria, which can require the neurocognitive assessment. If they've met the criteria for a different reason, let's say they had 70 decibels hearing loss, and they met the criteria on the basis of hearing, then additional assessments such as neurocognitive and or sleep apnea assessments, etc., you can sometimes get funding for additional assessments that impact on the function of the person if you can put it under the banner of their needs under NDIS. So I have seen that occur before, where we have successfully received funding for sleep apnea assessments and a funded CPAP machine for a person who was on NDIS for a different disability. So that is potential, but as I said, if the primary problem and the main problem is neurocognitive, then they're not on the NDIS until you have objective evidence and can complete the forms adequately to succeed in that application.
Doctor, can I now move on to some...
Sorry, just before you leave, may I ask a couple of questions? I'd just like to be clear that I understand some of the evidence that you have given. You've been in your position either acting or permanent from April 2018, I think, is that correct?
Yes.
The section that Mr. Griffin read out to you, section 22(4)A, Sentencing Act, that says the CEO corrections may use the information in a pre-sentence report to assist with the management of the convicted or sentenced offender to whom the report relates. That's been in the Act, you can take it from me, for the whole time you've been in your position. My first question is, and I understand you're not a lawyer, my first question is whether when you took up your position, you asked if you could have access to pre-sentence reports.
So not directly in as in that question. I've raised it as an issue, and people hadn't provided me that solution. And I'd also put forward the suggestion that we had paid neurocognitive assessments that health could have access to if they hadn't already been done as part of our reception assessment. And although I have been in this role since 2018, neurocognitive impairment and access to pre-sentence reports is only one of thousands of issues that I'm dealing with. My role is extremely broad, and we have a lot of health priorities all in competition with each other. There's a limit to what one individual can achieve. But
Dr. Rowland, I'm sorry, I just asked actually, I thought a rather straightforward question, which was whether you asked to be provided with pre-sentence reports, and the answer I take it is, from what you've said, no.
Not directly, no.
Wouldn't it have been very helpful to the work that you have to do to have access to those pre-sentence reports from the very beginning?
Yes, but I believe that it was more complex because it had already been looked at by other people, etc. So I didn't, if the solution had been that simple, why it had already been resolved.
I see. As I understood your evidence, you said that a decision had been made some 18 months ago for you, or at least the CEO corrections, to get pre-sentence reports rather freely, but that you didn't become aware of that decision until very recently. Have I understood that evidence correctly? Have you inquired why nobody troubled to tell you that this option was available?
I haven't made a formal inquiry. At the meeting in which I became aware of this, I asked, well, who, what action they had taken, and they listed a range of providers that they had added access to and indicated they hadn't thought of us.
Who is they?
The person who was adding it at the time, which I believe was a member of the, there was quite a few people at the meeting, but I think it was someone from the Disability Services Unit who said that, but whether or not they'd been personally responsible at the time, I'm not sure.
And have you actually had access to any pre-sentence reports since you became aware of the change of policy?
Not since. That's only a few working days we're talking about there. But I have previously seen some pre-sentence court reports when I have been able to gain access to them, particularly when I've been asked to respond or provide additional information. So there have been occasions when I have had access or seen them. It's just having that ready access for anyone, when I want it. They've had, is now a problem hopefully we have resolved, not only for myself, but for other members of the health team.
Thank you. The only other question I've got relates to something Mr. Griffin asked you. If it is a good thing or desirable for a detainee who is about to be released, for that person to have contact with a nominated health provider, would there be any difficulty about arranging a video conference for that purpose if the health provider is located in an area well away from Perth?
No, we use telehealth for a wide range of reasons, and we use it extensively. So being able to video conference to an external provider is certainly possible.
so that it would not be an insuperable obstacle that a health provider might find it difficult to travel, for example, from Kununurra to Perth.
Yes, that's true. I didn't have that in my mind when I was asked that question. I hadn't expected it. And
Thank you.
Doctor, can I now take you to that part of your statement dealing with screening and assessment of people with disability
yes,
at and following reception, which commences at paragraph 7 of JR1. Do you have that?
I'm not sure. Okay, yes.
You outline in that section of your statement what the process is in relation to prisoners and also detainees. Upon reception, a custodial officer will ask a series of questions about health and well-being, and that's outlined in paragraph 8. What does that custodial officer typically have by way of any records when they ask those initial questions?
I've not done that role, but they will have the transfer papers from the police, which can include a note from the police lockup. And if the person has attended hospital and received a fitness for custody assessment, they will have that note confirming fitness for custody. Sometimes that information includes an active problem the patient has or medication they've received or need to receive. If the person has been in custody previously, then they'll have information that's already on the TOM system, which can include the last med status update from clinical staff. They're the information I'm aware of. They may have additional information, but that's what I'm aware of.
Are there cases where they don't have any relevant information?
If it was their first time coming into custody and they've moved very quickly through the lockup, etc., there may be very little that arrives with them. Yes.
And in that situation, does the officer rely totally on the self-reporting of the person?
I believe the officer would, yes.
And you know from your experience that self-reporting can be highly inaccurate, don't you?
Yes.
For what reasons?
Lots of reasons. So people can not know the information themselves. They can not have understood information. They can use words in a different way. So the language becomes a barrier. They can choose not to provide information, or they can choose to provide alternative information because they believe there's some gain to themselves in that information. They can simply forget. So they're just some of the reasons. Obviously, to be able to respond to a question, you need to be able to process the question, formulate a reply, and articulate that reply. And there may be obstructions in any of those points.
After that, the next step is what you describe as the initial health screen conducted by a registered nurse. Is that right?
Yes.
That's done within 24 hours for adult prisoners and within 12 hours for a young person?
Yes.
Does that suffer from the same difficulty that if there aren't records, you're relying upon the self-reporting of the person?
Yes, so there are challenges when people come into custody in obtaining adequate information, which is why we build on it bit by bit. So these beginning steps, you begin with what the person is able to tell you and what information you're able to obtain from other sources. So a typical part of that initial assessment with the nurse is to ask them which services they use in the community. If they're under specialist care, have they been to hospital recently? And then the patients are asked if they would be willing to provide consent for us to obtain information from those providers. It may include their most recent pharmacy, for example. So the nurse will typically fill out multiple consent forms for the hospital, their GP, the pharmacy, etc., to obtain that collateral information from the community regarding their health status as soon as possible as part of the initial health screen. Nurses as well, in comparison to officers, are very accustomed to the restrictions and limitations of self-report and the way to ask questions in a variety of ways and to make observations of their own above and beyond what the person self-reports.
Yes. They use their experience as a registered nurse working in this environment.
Yes.
And the third stage, as I understand it, is what's called a doctor admission, which is a process by which an assessment of any person is conducted by a medical practitioner within 90 days of admission. Is that correct?
Yes.
That's quite a long time before they would automatically see a doctor. Is there provision for urgent assessment by a medical practitioner in particular cases?
Oh, yes, absolutely. So sometimes they're seen immediately on the day. The doctor on call can be contacted immediately for urgent advice and prescribing. And the nurse can book an appointment, immediately within the week, 2 weeks, 1 month. So the nurse is allowed to triage the person up to a 90-day maximum. Remember, quite a few people that come into custody are young and they've recently been in custody. We're familiar with their health status. They're fit and they're well. They report no acute problems. So the 90 days suits for the person who doesn't have any acute issues, and we don't expect to find acute issues, but the nurse can certainly book fast.
I'll now ask you some questions about how information is recorded. And you refer in paragraph 13 to the functional impairment screening tool known as FIST.
Yes.
Is that designed to particularly identify disabilities or other factors that are particular to a person?
Yes, so the information is recorded into the electronic medical record, so a compilation of all that information about the person, and the nurse will document on the templates, which there are copies of in the document. The FIST is a particular tool that we've developed, the aim being to screen for impairment, functional impairment that the person may have, and from there move on to do further assessments and delineation of that issue and ensure that appropriate aids or referrals are in place. So as a screening tool, it's really to identify, do we need to look further into this issue for this person?
The other thing it does, according to your statement at paragraph 15, is it gives you a snapshot of the population within custody as a whole to identify needs for restructure, training, etc.
Yes, so that's our aim. It is not only to assist the pathway for the individual person to ensure that we're optimising their functional outcomes, their access to services and aids, and our understanding of them, so we can provide patient-centric care, but also so that from a population-wide perspective, we can identify what percentage of people, for example, have a hearing impairment, a vision impairment, cognitive impairment, and that will differ from unit to unit. So where there is a particularly high needs unit, if custodial have access to this information, which has been part of our plan from the very beginning, they will be able to say, well, we have a particular problem in unit 13 with mobility. Do we have the appropriate equipment and mobility aids and assistance in that unit? Perhaps we need to do X, Y, Z. So we're hoping that with the better informed we are, the better likely we are to be able to target assistance and ensure that other issues such as infrastructure and staff training are appropriate to the needs of the people for whom we're providing a service.
Was FIST developed as a standalone program in Western Australia, or was the tool adopted from one used elsewhere?
No, we developed the FIST within our health service here. We looked for appropriate tools that would suit our purpose, and we couldn't find an existing tool that suited our purpose, that met all the aims, and we decided to implement our own with the expectation that as a screening tool, you would then move on to narrow into and look in more depth into an area. So, for example, the difficulties with activities of daily living and self-care. Our single scoring point for self-care would be followed up with the 3-page OT activities of daily living standardised score, which is used for ACAD assessments, etc. So we would use this as a springboard to know that we need to do further assessment for this person in that area.
Based on your experience to date, what triggers applying the FIST screening tool to an inmate or detainee, and what percentage of the custodial population are put through that screening?
So we implemented it and asked staff to complete the form just over 12 months ago now. And of course, since then we've had COVID, so that's interrupted slightly. Currently, we have 28% of the population, as of a couple of days ago, had been screened, and some sites are up to 80% of the population have had that screening done. We're asking staff to complete it as soon after reception as it's appropriate, because it's not always appropriate the minute they walk in the door when everything's unstable. It's embedded into the doctor's admission template, so if it hasn't been done prior to the doctor's admission, the doctor is expected to complete it. And we'd also aim to have it repeated annually as part of the annual health review done by nursing staff, if not done as part of a care plan visit, etc. As well as if there's a significant change in the health status of the person, that the FISP would be refreshed and would be updated to their current status. We're also, currently our primary healthcare nurses and doctors are the people completing the form, but we are hopeful that allied health services, including the mental health team, would also be very keen to participate and to update these forms when they see the need. As we collaborated with them in the development of the form, the intention is for it to be broadly available.
Just coming back to my question in part, I inquired as to what triggers someone being put through that screen.
So the trigger is admission. So coming into custody is a trigger. The doctor's admission is a trigger. It's embedded in that. The annual health review would be a trigger, and a change in health status would be a trigger.
So in paragraph 26, when you say by August 2022, 22% of the prison population had been screened, I think that figure's now 28, you said.
Yes.
Does that mean you're screening everybody that goes into prison, or you're selecting certain people on the basis of the nurse's assessment?
So we're asking staff, and we're encouraging and promoting it, that everyone is screened, even if no impairment is noticed, because otherwise we don't have valid data, and we can't tell how valid our data is unless it is across the board. We don't know who we're missing. When I've looked at the data in the past for myself and looked at percentage for ethnicity, for example, the percentage of patients screened that were Indigenous, the percentage of Indigenous patients screened was the same as the percentage of the non-Indigenous screen. The screening did seem to have occurred preferentially for older people versus younger people at that point in time. But remember, this is still in the implementation phase, and the 28% across the board indicates we still have, we still need to embed it in routine practice for staff to get up to across the board high percentages. Some sites have achieved high percentages.
Given the fact that you're heading towards screening 1/3 of the adult prison population, are the results so far indicating that the previous approach of initial screening was not terribly effective?
This screening does things that our previous processes weren't able to do, in terms of giving us a broad overview of what our problems are, and also being able to record in a way that's readily accessible issues such as, the person has mild visual impairment, but they're okay if they wear glasses, or they have mild cognitive impairment. You wouldn't normally add a diagnosis. See, the problem is the distinction in health records between diagnosis and function. So
I understand that, Doctor, but my particular question, if I can interrupt, is based on the information from nearly 1/3 of adult prisoners, are you now being more targeted and efficient in identifying conditions than you were under the previous system? And if so, by what factor?
To give an answer to that, we would have needed to do a QA of the files to compare it, which we haven't done. But because diagnoses don't capture functional impairment, my assumption is that because we're now particularly documenting functional impairment, that this will be an improvement. It should be an improvement.
Of the nearly 1/3 that you've screened of adult prisoners, what are the results showing in terms of disabilities being revealed in that cohort?
Yeah, so we're already seeing that different populations have different types of impairments, and the spread varies. So the remand prisons have a higher rate of, appear to have a high rate of disturbance in the mental and psychosocial and behaviour issues. and chronic disease is a heavy burden for people impacting on their function. We're generally seeing, I would take a guess at mild hearing impairment between sort of 1% and 3%, similarly for mild visual impairment. But, you know, because of that difference in population groups, and 28% is not a majority percentage, we're waiting till we have better quality spread before we, you know, pin too much on it.
Thank you. You've given the figure for the screening thus far of adult prisoners. What's the level of screening of detainees in Banksia?
The screening in the detention centre had been much lower. The staff there hadn't, we've recently sent, like in the last month, sent out additional encouragement and prompts for staff to attempt to do more screening. And I have seen an upsurge in the number done there, but it's not a high percentage as yet.
Why is that?
Because implementation of any change takes time and energy, and as I said, COVID has been interrupted over the last 12 months, and the staffing levels in the nursing at Banksia have been particularly hit hard in the last year. And so if there are small staff numbers, you prioritise urgent care and acute needs, and tasks such as completing forms, etc., become less of a priority and fall off. And change requires time and energy. So if this is something new, then they'll continue doing what they've done before until you get encouragement. But with encouragement, they are taking it up. So, you know, we're hoping this will be a big improvement there as well.
Doctor, based on your current information, when do you expect corrections to reach a level of 100% screening of adult prisoners and youth detainees?
There'll be so many variables that 100% is unlikely to be, because of the high turnover and disturbance. So 95% would be great.
Yes.
And maintaining that annually. So there'll be a difference between those who've ever had a screen versus those who've maintained it and it's up to date within the last 12 months, which will be one of the markers we'll look for. I would hope we'll see significant improvement in the next 12 months. At the rate that we're improving now, hopefully we would get to 80% at most sites within the first quarter next year, maybe. But
is one of the advantages of the FIST screening tool that it enables the identification of people that might be eligible for the NDIS?
Yes, because it particularly focuses people's minds and staff minds on where is this person at and what are their challenges, which can then lead to, well, now what do I need to do about it? So by having something that particularly focuses on functional impairment and challenges, it assists in that next step.
You also highlight in paragraph 32, a second gap which requires resourcing is the need to validate the FIST as being a reliable marker of impairment.
Yes.
And validate the consistency between users.
Yes.
Could you explain to the commissioners in a little more detail what would be required to validate to a scientific level those matters?
Yeah. So validation studies are a common sort of study that is done on new screening tools or questionnaires, etc. So I haven't run any of those studies myself, but essentially you would have different providers assessing the same person and not knowing what the other person had scored them. So you would look for consistency across providers. You would often benchmark it against an existing tool or existing tools to see whether it is equivalent or as good as. And you would look at whether or not it had real importance and real value, as in, if you measure a score of moderate impairment, does it actually have a real life application so that it's meaningful information, not just meaningless numbers? So there would be the three components I would imagine the study would look at.
Who will conduct that study?
Well, I've reached out to WAXA, which is the West Australian Community Service Research Division, and asked if they would have the resources or be able to provide it. And I've also, because I meet with other clinicians across the country and there's interest from other jurisdictions, someone gave me a name of people who are interested in the University of New South Wales, and if WAXA aren't able to do it, I intend to reach out to them and ask if they would run the validation tool over there.
Have the department indicated they will meet the cost of such validation studies?
No,
Have you asked them?
I haven't sent them a business case, no, but I've reached out, as I said, to WAXA and hope they would let me.
Commissioners, I intend to move on to another topic if there's any questions you have arising from what's just been discussed.
I'll ask Commissioners Mason and Paul McEwen if they have any questions.
Yes, thank you, Chair. I have a question about the FIST assessment tool. Thank you for the information that you provided, Dr. Rowland, on this new assessment tool that's been brought in, my understanding, November last year, and that is an improvement on collection of data done previously. In your statement at paragraph 15, you say there that the aim of the FIST is twofold. The screening and assessment function, and then there's the opportunity to get a snapshot of the population, the prison population as a whole, to identify needs for restructure, training required for staff, and planning for future resources. Prior to FIST being introduced, particularly in relation to those with disabilities in the prison system in Western Australia, what was the tool, the avenue to gather information for those particular aspects of restructure, training, and planning for future resources for people with disabilities?
So similar to the document that you received with the data from our department, we were limited to people registered with NDIS or with disability services alerts, and to diagnoses as a proxy measure of likely impairment without severity or percentage, and to our informal knowledge and what we were able to provide as our observations of what was required, which I have had opportunity in the past in some of the reviews departments done to discuss our high needs in chronic disease, mobility impairments, hearing, etc., and what infrastructure may assist. So it was informal, and the hope of this, it will provide us much more robust data to assess.
I think in your evidence today, you mentioned the word, or the words of the FIST being a better springboard for further assessments.
Yes.
Can you describe in lay terms, a non-medical person, what that means now for those who are incarcerated, and what that springboard means for a wider group of people now because of this new assessment tool, in terms of the way that those supports potentially in the future are being provided to them?
Yes. So, for example, if you did the assessment and noticed someone, when you did the cognitive impairment, you scored them as a 2, which meant that they had moderate impairment and it was impacting on their function and their relationships and communication. You could move from that single score of 2, which is limited, to performing a KICA-COG, which is the Kimberley Indigenous Cognitive Assessment tool, or you could do the MMSE, which is the other standard minimum mental state exam, is the next screening tool, which will give you a score out of 30 and is commonly used, or 39 for the KICA-COG. And from there, identify, yes, this person does have a significant impairment, and I need to consider, do they need a full dementia screen? Do they need an ACAT assessment? Do we need to assess the cause of this impairment? And if they're a much younger person, I wonder what the cause of this is, and do I refer to, who do I refer that person for, hopefully a cognitive assessment, or to the psychological health service to look at it, or the SPS to look at their behavioural education. So it prompts staff to say, we have an issue here. Exactly what is the issue? Is there anything remedial that we can provide from health services? What tools or assistance is required to optimise their function and minimise their distress and assist their engagement? And that may be other validated tools that are specific to that item, or it could be referrals to specialists, such as if you tick 2 on hearing, you'd refer to audiology or ENT to see if that person would meet the criteria 70 decibels, whether they could be assisted with hearing aids or surgery for the tympanic membrane or whatever that cause of that impairment is. So it's multifaceted. It's really, I guess the aim is it makes you think about it, so then you're more likely to do something about it, and you consider the person as a whole, and you consider them in what they want to achieve in life and what quality of life and what their functional impairments are. It aids people to think in that way, and that's the first step to behaving.
Dr. Rowland, very encouraging to hear that for a First Nations person incarcerated, if information comes out through this FIST assessment tool, that there's an understanding of resources in the First Nations community, such as the Kimberley Medical Service, that can be used, because we want culturally safe assessments and tools. The last question I have, Mr. Griffin, is to Dr. Rowland, is about the timeliness of young people in Banksia Hill getting assessments. Given just your evidence now and the incredible value of providing these assessments and the interventions, and you talked about the first quarter of next year, can there be something more firmer put in place to ensure these assessments are done for these young people, given the significant number of Aboriginal children in Banksia Hill? Thank you.
Yes, very happy to push the detention, and we have some other programs and activity to try to improve our assessment of the youth in detention and audiology assessments, etc. And I believe it will have a good response to the encouragement we've already provided.
Thank you.
Commissioner McEwen, do you have any questions at this point?
Thank you, Chair. Yes, one question for Dr. Rowland that relates to the interaction of the disabled person with, the doctor or the medical staff. So, for example, in the doctor admission that you referred to in paragraph 13, do you know if, say, for example, a person with cognitive or intellectual disability is provided with communication support when they are interacting with the doctor or medical staff, if you know that they've been identified as having such a disability before they arrive at the corrective services? How did that work?
Yes.
Doctor, before you answer that question, I've been asked by the Ausland interpreters whether you could simply slow down a little bit in your answers. Their task is made much more difficult if we don't speak both clearly and in a much more measured pace. No criticism, it happens in every hearing.
Apologies. Yes, so before the piece about slowing down, I've just forgotten what that question.
I hope I'm not guilty. Sorry, I hope I'm not guilty of talking too fast for the interpreting. So essentially, I want to know what, if any, communication support in the actual interaction with the medical staff is, say, a person with intellectual or cognitive disability. Can you just give me a picture of how that happened?
So there are a lot of barriers to good communication that health service providers would be familiar with from their years of experience. So these would include not only sensory impairments, processing, communication issues in them, understanding, language issues, not only different languages, but different use of common terms, and their ability to communicate and express themselves. So typical adjustments that you would make would be to speak slower, to use simple language, to use visual prompts and aids, to use body language, and to allow them time to express themselves and to take effort to understand what works for them in terms of communication. So I'm familiar with that process myself, having worked as a clinician for a long time. And I've also seen my colleagues and I've seen nursing staff use those techniques and work with the person in a patient-centric way of showing respect, gaining rapport, and ensuring that communication is occurring in both reception and understanding and listening well. So those are skills we encourage. They're part of codes of ethics. They're part of the RACGP accreditation. That it's patient-centric, that you communicate, that it's collaborative decision-making. You can't have collaborative decision-making if you haven't first ensured you have good communication. So that culture of ensuring you have communication is something we strongly encourage as an embedded in our policies. In terms of specific assistance for people with impairment, apart from using visual aids, and we've often got models, so models of the heart and models of the knee, etc., in clinics that we can pull out and actually show and demonstrate exactly what we're talking about. If they need a family member or a carer that is within the facility, we can make arrangements and ask to see two at once in more of that yarning family style, so they have that assistance where that is possible.
Thank you. Yes.
Okay, thank you. Sorry, just to be very clear then, so with all those big tools that you mentioned, just to be clear, and the doctor admission, if a person does need a communication support worker with them, that will be provided at the time of the doctor admission.
If it hasn't been identified that it was required beforehand, then the doctor will do what they can in terms of what is achievable and can book a second visit or a third visit to complete it. It's often the case that we can't complete the whole assessment in one sitting because of our limited resources. We allocate 40 minutes now for that assessment, but 40 minutes is often not sufficient to complete the whole aim. And so you start it then and sequentially over time. We can access interpreters on the phone pretty much immediately for most people if we identify it to be a actual language area.
Yep, thank you for that.
Yes, Mr. Wood.
Dr. Rowland, there are no specialist designated disability units in Western Australian prisons, according to your statement.
Yes.
When you have somebody with severe non-physical disabilities, what options are available to you as a health service for their care?
So non-physical disabilities are a broad group you've described there, but accommodation decisions are worked out in conjunction with custodial staff. So we identify what the components of their accommodation that they require might be. So that might be that they need, bottom bunk, or they need a carer with them in the room, or they need a bathroom with ability to provide assistance. We would then discuss with custodial to say, which accommodation unit would best suit them, where those needs can best be met and the person is most comfortable. Often that relates to where their family is and where they feel they have their social supports and where the person is most comfortable and familiar.
What if they need to be hospitalised or the equivalent thereof?
Yes, so we have access to hospitals by referral, but if, for example, someone has very high needs, we identify what those needs are and we try to accommodate them in the infirmary. So we have managed people with quadriplegia and paraplegia. We've managed people with ventricular assistant devices. We've managed people who require assistance with all activities of daily living and severe respiratory disease, etc. So,
Dr. Rowland, perhaps my question wasn't clear. I'm looking at the non-physical disability, people with really severe mental disabilities of one sort or another. Now, you can deal with them in prison or the detention unit, but if they're a more severe case, what are your options outside for their care?
I'm not aware of us having any prior prisons in long-term external accommodation purely for non-physical needs. People with severe intellectual impairment, as for example, if that's what you're referring to, would often be linked with a carer who would spend all day as their second person, assisting them to navigate the daily routine of the prison system and assisting them with self-care or care of their room, etc. So Those sorts of support processes are put in place in conjunction with custodial.
What about if they're at risk of self-harm?
So we have the ARMS process, the at-risk management system. So if someone is at risk of self-harm as an acute basis, they will be on the ARMS system, which has the multidisciplinary assessments and the PRAG committee to assess that risk and make decisions about accommodation. If they are chronically at risk and vulnerable, we have the SAM system, which is the support and monitoring system, which ensures that they have additional monitoring and attention, and they will have regular interaction with psychological health services to just check their welfare and make sure they're travelling okay. We also have the Aboriginal Visitor Scheme, which is an internal service which enables that, again, that supportive contact to ensure that someone is travelling okay on a regular basis if they're recognised as being vulnerable.
In paragraph 57 of JR1, you say, and I quote, "The minimum standard for provision of health services to people in custody is the concept of community equivalence. The minimum standard is the standard in the community." That's the fundamental principle your section works to, isn't it?
That's what we're held to. I would like to provide higher than the community, because the community has often failed the people that end up in our system. And this is a particular opportunity. We have a unique opportunity to assist people who have fallen through the gaps. But in terms of what we're funded for and what we're held to officially by the government, it's this concept of community equivalence, which we, as I say, strive for that and beyond where we can get, where we can.
Based on your observation during your 4.5 years, is this minimum standard being met for prisoners and detainees with disabilities?
I think it varies. I think often we do manage to achieve better than the community, and we've had such statements made in the coroner's court after assessing our care for people, that they have agreed that the care some individuals have received has been above and beyond what they would have received in the community, particularly if they've been in the infirmary with high needs. But I'm sure that there will be examples and there will be individuals for whom, despite our best intentions, for one reason or another, we have not reached the standard that I would like and that we would be aiming for.
In what areas have, in your view, you failed to meet the standards set out in paragraph 57?
I think there are areas of patients who have some of the mental health conditions, such as personality disorders and etc., where it's a struggle to provide a therapeutic environment and to provide the counselling services, the chronic PTSD, the childhood complex PTSD, where that therapeutic environment, therapeutic counselling, wraparound care to assist them is challenging, and more challenging than it would be in the community, partly because of resourcing and limited resources for that, but also just the nature and infrastructure of the prison environment and how, for someone with complex PTSD, childhood challenges, etc., it's difficult to make a prison environment a therapeutic environment.
Well, indeed, a prison environment and a detention environment are self-evidently not a good therapeutic environment. That's correct, isn't it?
Currently, you know.
And so consequently, if you want to have equivalence with the community, would you look to having that prisoner or detainee placed in an acute involuntary psychiatric treatment place?
No, not for those long-term conditions that I've met, because the acute inpatient psychiatric facilities are reserved for people who require Form 1 and are acute severe distress.
And I want to focus on those people for a moment, because I'm conscious of the time. If you have a prisoner or a detainee that is assessed as being acute involuntary psychiatric category, what options do you have available to you in Western Australia?
If there is not a bed in the Franklin unit, then we need to manage them in the prison. and they'll be managed often under arms because of that risk, often in a CCU bed or a high dependency unit where they can receive that frequent observation, and they'll be seen by the mental health team and the psychological health services as part of that ongoing care.
Let me go back a stage. Where's the Franklin unit? How many beds does it have? And how many beds of the total would be available to corrective services?
So the Franklin is the forensic mental health unit. So it has 30 beds, but the mixture for people that require the forensic beds is made up of people on hospital orders. So
Yes.
they've not actually been, you're sure you lawyers, you're more familiar with hospital orders than I am. So a mixture of people on hospital orders and people who have come from custody. That number is inadequate for our demand and has been for quite some time.
When you say for quite some time, have there ever in your experience of 4.5 years been adequate external beds available for that category of prisoner or detainee?
No.
Does that then throw back upon you and your team trying to treat those people within the custodial setting?
Yes, it has significant flow-on effects within the prison system.
What barriers do you experience in your team when trying to provide adequate treatment within a custodial setting for those people?
So prisons are not a therapeutic environment. Assisting people to calm and to reduce their distress is difficult with the infrastructure that whereas a Franklin unit is staffed by mental health professionals fully and they're surrounded by them all day, they get intermittent interaction in the prison environment. We are able to provide non-consensual treatment, which is able under legislation to be provided in the Franklin unit. So they're potentially missing out on medication, which could help them, but can't be provided without their consent unless they're in a unit such as Franklin.
Just pausing there, is that the first barrier you confront, that inability to do what can be done in the Franklin unit in relation to medication and other things?
And I think that we can't be a Franklin unit within the prison. So, yes.
Does that result in prisoners or detainees frequently being placed in isolation?
It does contribute to isolation because of the arms and the risk to self and the infrastructure required to protect them from themselves or protect other people from them if they're acutely distressed or violent and aggressive, etc. So that, yes, they would spend more time in seclusion because they can't be admitted to Franklin.
And if they're placed in seclusion, in your experience, does that increase the chance of self-harm or other deterioration in their condition?
Well, it's not therapeutic, and without the relief of distress that might be possible within Franklin, their distress will continue longer and potentially be more severe because they remain in the prison system. So
and when you use the term their distress will continue, is it fair to say what you're saying is their condition will deteriorate in that environment?
Yes, it can deteriorate. Some people do improve and they can be removed from the Form 1A prior to and having never received Franklin, that they will improve and receive treatment. But for some, yes, their condition can deteriorate and be exacerbated or continue.
And I mean no criticism in this question. Doesn't that mean that you can't meet the community standard because of the barriers you've identified for that cohort of prisoners or
Yes.
detainees?
For mental health, patients are a particularly challenging group to meet their needs because of these challenges, and Franklin is definitely a challenge.
And that will include, won't it, some detainees who are on remand and who have not yet been convicted of any criminal offence?
Yes, and if they're not given a hospital order as part of the assessments in court, which is often achieved, if they're on remand but they don't get a hospital order but they're on forms, then yes, they are impacted by the Franklin problem.
Thank you.
Isn't another consequence of what you've said that a prisoner or detainee will effectively remain untreated if they can't be put in a specialist place?
If they continue to decline treatment and not provide consent, yes, their treatment is pending that involuntary treatment that can be provided at Franklin.
And so if they're on remand, they're there for whatever reasons the court has determined. If they're sentenced, the sentence is to deprive them of their liberty. What's happening to these people, I suggest to you, Dr. Rowland, and once again, I don't criticise you, is they're suffering a further punishment, that is a deterioration in their mental health because they can't be adequately treated. Do you agree with that proposition?
I agree that it's detrimental to not have access to Franklin. Absolutely, yes.
Well, do you agree with the proposition that in that scenario, they suffer a further punishment in that their condition deteriorates because they can't receive the treatment they would receive in Franklin?
It's a further consequence. A lot of these people also have difficulty accessing services in the community. So there is a bed shortage even for people that are not in custody in mental health beds. So often they've ended up in our service because they were unable to access appropriate services in the community as well. So again, it's not just confined within our wards, it's a broader problem.
I don't think that was the question Mr. Griffin was asking. Perhaps I might ask Mr. Griffin to ask the question again, and if you wouldn't mind attending to the specific question and then give us your answer.
I think I was putting the proposition, but I don't have a transcript, that the effect of them not being able to be put in a place such as Franklin is that they receive a second punishment, that is their condition deteriorates because you're not able to provide the treatment that they would otherwise be entitled to.
In terms of the use of the word punishment, punishment implies that it's a direct or intentional consequence to negative behaviour in the aim of, you know.
Let me substitute the word punishment with disadvantage.
Yes, a negative consequence. Yes, there's a negative consequence to being not able to access care, but it's not punitive on our behalf. In fact, a lot of effort is gone into support them, and a lot of distress is felt by staff and vicarious trauma in trying to do their best in adequate resources.
Have you raised with the department concerns relating to what we've been discussing in the last 10 minutes and how difficult it makes it for your staff to do their job? Yes,
these concerns have been raised not only by myself, but by the psychiatrists, by the mental health commission are aware. There have been documents produced in WA about the plan going forward for the mental health care in WA. I don't think there's anyone denying that Franklin unit is too small at any level of government. Are you aware of any current plan to rectify that situation? Yes, I've heard of various, but there is a long-term plan to provide more beds and build a new building. But as to the development, where they're up to, I don't have personal information as to the current plan or timing. Well, can I ask rhetorically, Dr. Rowland, what happens to the people in the interim whilst this plan wanders its way around the landscape? Yes, and as I said, staff experience distress, and these conversations have gone around in circles for a long time, and I've been present at meetings where they've been raised. The Department of Health is aware, the ministers are aware, documents have been written. It's not, it's something I witnessed, it's not something I have control over. Have you had discussions with any Aboriginal community organisations or medical services as to how they might assist in relation to those in custody with a First Nations background? The Department of Justice has a mental health AOD division, and they employ Aboriginal mental health workers as part of their team. It's an additional member of their multidisciplinary team that has come on board. So as far as possible, particularly as the Mental Health Act requires us to do so, but just for general common sense anyway, There are now Aboriginal mental health workers. We also work with the Aboriginal Visitor Scheme for patients who we believe would benefit from, a visit or interaction because we have concerns about their health or access to health or the comfort in whether or not they're willing to access care.
Dr. Roland, I wonder again if you wouldn't mind attending to Mr. Griffin's question and answer it directly. I'll ask Mr. Griffin to ask it again, or perhaps I can do it directly from the transcript. The question was, have you had discussions with any Aboriginal community organisations or medical services as to how they might assist in relation to those in custody with a First Nations background?
No, firstly, I've not had those conversations.
When you use the term AOD, that's alcohol, other drugs?
Yes, yes.
Thank you. In paragraph 86 of JR1, you were asked, are you involved in a development which is referred to as a trauma-informed model of care? And you answered no. Firstly, do you understand in broad terms what a trauma-informed model of care is? And secondly, can you explain why you haven't been consulted in respect to that?
So I do understand trauma-informed care. It's something I became aware of prior to my arriving in the department and something I've explored. You have a copy of my CV. I've attended additional training specifically related to trauma-informed care. The concept of trauma-informed correctional care is something that I have brought to the department's attention in the past, and we have put trauma-informed care in our health descriptions and model of care for some time. I was aware that the department was putting in place education processes, and the department itself put trauma-informed care in the women's model of care document some years ago. So I was aware that they were proceeding with following that process. I'm aware that there's training for the youth custodial officers. So I believe the department is aware of trauma-informed care, that they're proceeding with it, they're appealing to appropriate specialists. I'd be very happy to be involved, but obviously they haven't felt the need to involve me directly.
Do you know why you haven't been involved, given your extensive and pertinent experience?
I don't know, but we have a director of health services, and then there's an assistant deputy commissioner above him, etc. And so I'm buried a little bit in the structure of the department, and that's potentially why.
But you are aware that this model of care was recommended by the Inspector of Custodial Services in Report 141 of March this year.
I wasn't aware of that specifically, but I knew that we were already making moves around trauma-informed care in the women's space and the youth detention. And as I said, in our health models, we've arranged education for our general practitioners in trauma-informed care well before March 2022. So had I been aware of it, I would have been supportive and not surprised. But no, I wasn't personally aware of that recommendation.
Dr. Roland, I note the time. They're the questions I want to ask you, but could you just wait a moment to see if the commissioners have any questions?
Yes, thank you. Commissioner Mason, do you have any further questions?
No, thank you, Chair.
Thank you. Commissioner McEwen?
No, thank you.
Dr. Roland, thank you very much for your evidence today and for the information you've provided in writing through your statements and responses to questions asked by the Royal Commission. We appreciate your assistance on the important issues that have been raised at this hearing. Thank you.
Thank you very much for this opportunity.
Mr. Griffin, do we now take a break of, let us say it's now, I'll have to do some arithmetic here, 7 minutes past 10 more or less in Western Australia. Shall we resume at 25 past 10?
Thank you, Chair.
The Royal Commission is now adjourned. The Royal Commission is now in session.
Yes, Mr. Griffin.
Chair and Commissioners, I call Wade Reid and Dr. Angela Cooney to give evidence. I understand they've both made affirmations.
Yes, thank you very much. Mr. Reid and Dr. Cooney, thank you very much for coming to the Royal Commission remotely in order to give evidence. I will explain where everybody is located, just in case you don't know. We have Commissioner Mason and Commissioner McEwen in Adelaide joining the hearing remotely. I am in the Sydney hearing room. Mr. Griffin, Senior Counsel assisting the Royal Commission, is also in the Sydney hearing room, and I shall ask him to ask you some questions. So thank you very much for coming. And now Mr. Griffin will ask you some questions.
Chair and Commissioners, can I indicate that Mr. Reid is the Superintendent of Banksia Hill Detention Centre. He has provided a statement for this public hearing dated the 10th of September 2022, identifier STAT.0631.001.001. The statement is in hearing bundle C1 at tab 36. The attachment entitled WR1 in response to a statement for information WA-NTG-00019. The attachments appear at tabs 37 to 47. Can I indicate that Dr. Angela Cooney is the Deputy Superintendent, Rehabilitation and Reintegration at Banksia Hill Detention Centre. She has not provided a statement. She appears because Mr. Reid states in paragraph 1 of his statement that Dr. Cooney has provided him with advice and information in relation to responses to most of the questions in the notice which was addressed to him. Can I start with you, Mr. Reid? How long have you been the Superintendent of Banksia Hill Detention Centre?
Since the 1st of November 2021.
And prior to that, were you the Superintendent at 7 different prisons in Western Australia?
I have been over a period of time, yes.
And prior to working in Western Australia, were you working elsewhere in the corrections?
Only in Western Australia.
Only Western Australia for the past 32 years?
Just over 32 years, yes.
Dr. Cooney, can you give the Commissioners a very brief outline of your background?
Yes, so I'm a registered psychologist with endorsement in forensic psychology. I started with the department in 2006 as a psychologist, and I've held various positions in the department or in the justice sector since that time. Immediately prior to being the Deputy Superintendent, I was the Principal Psychologist in youth justice for a period of about 2 years. I was asked to go into the Deputy Superintendent role in November 2021, and I've been in this role since.
What does the title Rehabilitation Reintegration involve?
So I essentially oversee and coordinate all of the various services at Banksia Hill who contribute to rehabilitation and reintegration. So that would include education, case planning. Although the psychology and health teams don't report to me, I support them on site to ensure that they're operationally supported and that we have sufficient coverage provided at the centre.
How do you measure your success or otherwise in relation to rehabilitation of detainees?
It's not something that we actively do at Banksia Hill per se. There's obviously statistics which show the percentage of young people that would return to custody. For us, in the short amount of time that I've been in the role, we've really been focusing on direct feedback from the young people. So we've created a youth leadership council where the young people provide us feedback about the services that we're providing and whether they feel like their needs are being met. And we also work closely with youth justice in the community to try and support through care as much as possible.
Did I understand you that despite the fact your title is rehabilitation and reintegration, you don't actually focus on rehabilitation?
So no, we do focus on rehabilitation. So a lot of the programs that we provide are focused specifically on rehabilitation. So we use the model, or essentially all of our services are provided in line with the risk need responsivity model, which is one of the leading models on rehabilitation. So everything that we do, we think through that lens of the risk need responsivity model.
So in simple English, what does a risk need model entail?
Yep. So it was a model developed over many years by a number of researchers, and essentially, in summary, what it says is that in order to be effective in rehabilitation, you need to focus your intervention on what we call criminogenic needs. You need to target the right needs. Essentially, if you target needs that are not related to offending behaviour, then that's not going to reduce the risk. And the other element of the model is that your more intensive resources need to be targeted at your higher risk offenders. And low risk offenders should actually be diverted from the system as much as possible.
So thank you for that explanation. You apply that model in your work?
Yes, we do.
How do you measure the success of the work you do based upon that model?
So individual programs would have pre and post test measures. For example, some of our programs that focus specifically on criminogenic needs. So we have a number of those programs out there. So you can see if an individual program is working, but overall, it's probably looking at reoffending rates.
Okay. I'm a simple man. What does criminogenic mean?
So that's essentially the needs that we know relate to offending behaviour. So, for instance, self-esteem, people might think, a target treatment at self-esteem, but we know that that doesn't reduce offending. So essentially, criminogenic needs are needs that have been identified through research as directly correlating to risk of reoffending.
Can I take it that you would never use that term when talking to a detainee?
Definitely not, and I wouldn't use it talking to staff either.
So I want to press you on this issue of you applied this model, you've explained in some little detail about how you do it. How do you determine whether it's working or not with the detainees?
So like I say, part of it is feedback from the young people. So are the services that we're providing sufficiently engaging? Part of it is individual programs having outcome measures. And then part of it is looking at reoffending rates.
Are part of those services education programs?
Yes.
What education programs do you currently have operating in Banksia?
So we've got a school that caters for all the young people in Banksia Hill. They focus predominantly on literacy and numeracy. They do an assessment whenever a young person is admitted to determine what level of functioning of literacy and numeracy that young person has. And then the school, the education program that's then provided to them is tailored toward their level of functioning. In addition to that, we also provide various vocational kind of courses. So that can be things like a barista course, there's a hairdressing salon, there's the other example just slipped my mind. But yeah, we provide both a combination of literacy and numeracy and then also vocational type courses.
And do I understand that school is compulsory for all detainees?
Yes.
What happens with detainees who are in isolation?
So they should still be provided school in on one-on-one basis or in small classes. The teachers will attend the units that the young person is based in.
You said they should be provided. Are they provided with education for each and every day they're in isolation?
So there have been some challenges with that due to staffing, which I think Mr. Reid will cover in depth. But it is the intention to provide it to them, but due to some staffing and operational issues, sometimes that's not possible.
So in this hearing, when I hear the word challenges, do I take it that it hasn't happened?
I would say there's been periods of times where young people haven't received education due to the staffing issues.
Would you say they are long periods of time?
I would say it's intermittent because every morning we essentially assess the level of staffing and what we can provide on the day. So it would be intermittent rather than a prolonged period of time. So it might be 1 or 2 days here or there rather than it consistently being an issue.
Does it follow from that that the person in isolation would have to be taught at their own pace because other detainees not in isolation would be moving ahead in the course whilst it wasn't available to them?
So everyone's taught at their own pace. So the teachers, the classrooms are really small and it's an individualised approach. So you can have people in the same classroom who are operating at slightly different levels and require individual focus. So the teachers are really skilled at adjusting as required.
Mr. Reid, can I come to you? You outlined in your statement the physical layout of Banksia, having 9 general living units, 8 for boys, 1 for girls, that's correct?
Correct.
There's an intensive support unit known as the ISU, which has 4 wings, A, B, C and D.
Intensive supervision unit, yes.
Yeah. There are multi-purpose cells within B wing that are a last resort option for immediate short-term placement of detainees as an immediate response to an incident. In simple English, what does that mean?
Those rooms are used for those detainees at the most acute level of risk and needing the highest levels of observation.
And typically, what are you observing for?
For the safety and security of the individual detainee.
Does that mean that those people typically are at risk of self-harm?
Quite often they can be in that environment, yes.
Did you hear the evidence of Dr. Rowland?
Yes.
When somebody is at high risk of self-harm or experiencing an acute psychiatric event, how can you treat those detainees within Banksia if Franklin's not available?
They are generally managed if they are at acute level of risk to themselves on the at-risk management system. If they are at that acute level of risk, they'll be in B wing and they'll be in observation. An interim management plan, which involves a multidisciplinary team, will decide the placement and the supports or interventions that that individual needs, and they'll be monitored depending on which level of harms that they are on.
Well, that involves watching them. Is there any active treatment provided to them?
Yes, there is interventions from health and or psychological services, and sometimes other services, depending on the circumstances for the individual detainee.
Is your experience the same as Dr. Rowland, that on occasions, detainees that ought on medical grounds be in Franklin aren't able to be transferred because of the unavailability of beds?
The advice and observation that I have is that the health facility with the acronym EMU and EMYU, we've had very good capability of getting detainees that need that mental health placement facilitated.
Well, does that mean on every occasion it was determined somebody was experiencing an acute event, they were able to be housed at Franklin?
They're not housed at Franklin, they're housed at in Bentley at EMU.
So on each occasion, somebody fitting that category was able to be moved from Banksia to either of those places, or were there occasions when they had to remain at Banksia?
My experience is that where those acute psychiatric issues have occurred, we have a good relationship with EMU, and we've had assistance from the mental health advocacy support unit. Where they've been assessed as requiring to be moved, that has occurred.
Without exception?
That's my understanding.
Well, on what basis do you have that view?
On my experience since being placed at Banksia in 1st of November.
Right.
Have you had discussions with Dr. Rowland about that issue?
I haven't had discussions with Dr. Rowland, however, I do discuss with my staff on site, and I am appraised of when people with mental health issues need to be referred to another facility, and I'm acutely aware of those when they occur.
Having listened to Dr. Rowland's evidence, you appreciate that your perception is not her perception, don't you?
In relation to juvenile detainees, that's my response.
What is your response?
That where juvenile detainees require movement to a mental health facility, we have a good relationship with EMU, with the assistance of the Mental Health Advocacy Unit, and generally those placements are occurring.
Wouldn't Dr. Rowland be precisely the person you should consult about this to get the best information?
If we were not getting, I think there might be a mix up there. I'm referring to EMU, not transfers to Franklin.
Can I just interrupt for a moment, Mr. Reid? Is EMU, and it's that EMYU,
That's correct.
is that a 12-bed inpatient service?
Answer that one.
Yes, that's East Metropolitan Youth Unit. So that's the youth version of Franklin. So Franklin is only for adults,
Yes.
and EMU is the option for young people.
And who runs EMU,
Department of Health
and where is it located?
in Bentley, I believe.
And is it your experience, Dr. Cooney, if you have knowledge of this, that any detainee that required the services of EMU was able to be placed in that facility?
Yes, certainly over the last 12 months, Mr. Reid and I have, we've had, there was one young person where there was a delay because of lack of bed availability, but we got support from the Mental Health Advocacy Service, and that admission was facilitated within a week, I believe, from memory. But all of the other young people who required admissions, it's happened in quite a timely manner.
Mr. Reid, in addition to Banksia Hill, there's also Unit 18 at Casuarina Prison.
Yes,
That, I understand, was gazetted on the 13th of July 2022 as a young offenders detention centre on a temporary basis for 12 months.
correct,
That was a decision taken by Dr. Thomason.
correct,
And I understand on the 20th of July 2022, 17 detainees were moved from Banksia Hill to Unit 18. Is that correct?
correct.
Now, Doctor, I think that's said to be in response to recent challenges at Banksia Hill, including young people escaping from their cells. Were you involved in the decision to make that transfer with Dr. Thomason?
I would have been involved in supplying information in relation to the state of Banksia at the time of that decision making.
And to clarify, your official position is Commissioner, correct?
Superintendent Banksia Hill.
Sorry, Superintendent. And in relation to Banksia matters, do you liaise with the Commissioner for Corrective Services, Mr. Reynolds, or Dr. Thomason, or both?
My direct line reporting is generally, as recently been to the Deputy Commissioner, is Christine Ginby.
And she's deputy to Mr. Reynolds, is that right?
That's correct.
And Mr. Reynolds has a delegation from Dr. Thomason in his role as Commissioner. Do you understand that to be correct?
Yes,
So your main dealings are with the Deputy, not with the Commissioner?
that's correct.
In your discussions with the Deputy Commissioner, what factors were taken into account in considering moving detainees from Banksia unit to Casuarina?
The situation from my time of arriving at Banksia had evolved. When I first arrived, 1st of November 2021, we had challenges predominantly in relation to staffing and the rate of incidents within the facility. However, as we came into early 2022, the nature of the incidents within Banksia had changed and provided a greater threat to the safety and security of Banksia, namely the rate of assault on staff, but particularly the ability to contain detainees within their accommodation during the day and the night. So to provide a safe environment and to recover Banksia Hill and provide safety and security for detainees and staff, the information was discussed that it was an option that needed to be considered for alternative placement for those detainees which presented the highest level of risk.
In respect to staffing of Banksia, I understand from a response provided to the Royal Commission that the Department of Justice doesn't apply staff ratios to Banksia Hill or Unit 18. Is that correct?
There is a ratio, I understand, at the moment that might be 8:1, but they're based on functionality.
Well, where do we find that ratio in a document?
I can't answer that.
Or where did you get that information from?
Previous conversation
With?
with the ex-Deputy Commissioner, Mr. Andrew Beck,
And how long ago was that conversation?
several months ago, because in the considering a whole range of issues that needed to be addressed for Banksia Hill, the staffing is obviously something that needs to be looked at, and there would be best practice across Australia. And in those conversations, I recall conversations as being that the ratio would be roughly 8:1 at Banksia.
8 staff members to 1 detainee?
No, the other way around.
1 staff member to 8 detainees?
That's correct.
Well, let me try and clarify that. In August of this year, the average daily detainee number in Banksia was 74, according to your statement. Is that correct?
Sorry, repeat the date, please.
In August 2022, the average daily detainee number in Banksia was 74.
Okay.
Do you agree?
It may have been. It's slightly higher at the moment. It sounds low.
No. Well, I said in August 22, when your statement was made. Do you have your statement in front of you?
I do.
Could you turn to paragraph 62? And that's in WR1, which is the notice. Do you have that in front of you?
Yes, I do.
The heading is Staff Ratios and ISU Policy. The question asked is, what is the current ratio of staff to detainee in the ISU? What is the current ratio of staff to detainee in the detention centre generally? You can see that?
Yes.
Paragraph 62, the response, the Department of Justice does not apply staffing ratios to Banksia Hill or Unit 18. We've just covered that. Paragraph 63, the average number of detainees in Banksia Hill in August 2022 was 74, and the average daily staff number at Banksia Hill for this month was about 105. Where did that information come from?
I can't recall how that information was supplied.
Well, you're the author of this document, are you not?
That's correct.
Well, try and recollect.
Sometime since the creation of that document.
The document's dated the 10th of September.
Yep.
That's only a matter of weeks ago.
That's correct.
Where did you get that information from?
I cannot recall the source of that information. However, the number of staff does not refer to the average daily number of staff, of custodial staff specifically in that sentence. There's a large range of other staff on site.
Well, I'm sure there is, and I'm going to come to that because I'm trying to understand. And to try and make the process easier, Mr. Reid, I'm trying to work out on an average day in Banksia how many people are working there And how many people are they taking care of? I know it varies.
Yes.
Without going through all the detail at this point, are you able to say, as of today, how many detainees you have at Banksia?
Yes, I have roughly 83 detainees at Banksia today and 10 at Unit 18.
Right. So a total of 93 between the two locations.
Roughly, yes.
How many staff members work currently on a weekly basis at Banksia?
Recently, we've been averaging roughly 30 to 35 staff per day. Sometimes that number can be higher, sometimes it can be lower. From Monday to Friday, there'll be a large number of public servants that are additional to the YCOs that carry out a range of functions such as the management of the facility, case management, visits, and so forth.
And how many of your staff are working at Unit 18?
Today, there is a total of roughly 10 staff, but that will include YCOs and some prison officers. And then there's the management team and support services to complement that.
Right. How many boots on the ground currently are there on an average day at Banksia and at Unit 18?
It varies, but at the moment, we have numbers of roughly 30 to 35 per day at Banksia and up to roughly 10 at Unit 18.
And of those 30 to 35, what are the job designations of those people? How do you group them?
Every morning, an appraisal of the staffing situation is made from the operational leads. We have requirements to meet obligations to get detainees to and from court and provide regional escorts. We have requirements to man the entry building and the front gate and the security services in that area. We have all of the accommodation areas that I already referred to. We have the official visits area and visits areas that need to be staffed to maintain those functions and a range of other services on site.
Would it be accurate for me to say that 30 to 35 are custodial staff? Is that an accurate description?
That's correct, yes.
And so of the custodial staff, there appears to be a ratio of 1 to 3.
That's because when we're talking, as it mentions in my statement, the department doesn't officially apply staffing ratios at Banksia Hill.
Yeah, but I'm applying one, doing simple arithmetic of saying roughly 90 detainees in Banksia and between 30 and 35 custodial staff. That would suggest a ratio of 1 to 3, correct?
No, not in relation to detainee-facing roles. As I mentioned, there's a wide variety of roles across the facility. So, for example, if you took the staffing for the escorts and the recovery positions and the front gate and a whole range of other positions that are within the site, not all of those roles are detainee-facing.
Yes, I understand when you use the term detainee-facing, but they're all custodial staff of one sort or another, whether they be manning a gate or dealing with a detainee, correct?
They are.
So assume today we have 35 people working at Banksia.
Mm-hmm.
What other staff members are there on an average day and what do they do?
We have the management team itself, which oversees the operational and strategic management of the facility.
How many in that group?
Roughly 8.
Okay. Next group?
There is the security unit, which has a security manager and 4 or 5 security staff, which overlook security processes, procedures, intelligence.
So 5 or 6?
Roughly, yes.
Next group?
You would have some staff that are involved in looking after the accommodation units, and the number that are managing the accommodation units can vary greatly depending on the availability of staff. However, we always try and maximise that.
So how many on an average day would that be?
It can vary greatly, but between senior officers, unit managers and YCOs, it might be up to, on a good day, 20.
Okay. Next category.
We man areas such as official visits and social visits, and we also man education. So not all of those staff are static. In the morning, the detainees are woken up, or they awake, and they go through their morning routine. But as you've already heard through the evidence, they're required to go to education and to programs. So largely the staff move with those detainees and provide a wide range of services across the site.
On average, how many of those people on a day?
Well, if we have a full complement, there's 6 staff that are involved in internal escorting. There would be 3 or 4 staff involved in relation to supervising visits and official visits. And there would be staff almost always positioned within the intensive supervision unit.
How many of those?
So the admissions unit has a range of duties, not only in relation to admissions, but work that surrounds that. So there would be roughly 3 staff in the admissions area at any one time as well.
Any other groups of staff? What about people teaching?
There is a range of teachers on site, yes, that's correct, which doesn't come into the YCO complement. However, the YCOs provide supervision to the education area while education for the detainees is occurring.
Who pays the teachers?
Department of Justice.
All right. How many of those on average?
Yep, so it's approximately about 20, I believe.
Okay. Health staff?
Yep, so we have health staff on site, typically 2 nurses during the day and 1 nurse overnight shift. Got a psychiatrist who attends the centre half a day a week. Got dentist who I believe attends once a week or once a fortnight, and a GP. Then we've got the psychological, and mental health. There's a mental health nurse as well, health services. Then we've got the psychology team. So we're allocated 6.6 full-time equivalent for the psychology team. There's the case planning team where we've got 4 case management or senior case managers, a coordinator of programs, and the manager of case planning. We've got 4 Aboriginal youth support officers, and that's being extended to 8. We're just undergoing the recruitment for that now. Then we've got other services that kind of do in-reach. So we've got a chaplain, which is essentially 1 FTE, and some mentor services.
So can I approach it this way? How many people does the Department of Justice pay on an average day, weekday, to attend Banksia to do all these different roles?
If we had a full complement every day.
No, so first up, tell me how many on average currently, and then I'll move to what the ideal would be.
If you're talking about YCOs currently, we are getting 30 to 35 staff roughly attending per day. And then we have roughly 40 public servants on site per day, Monday to Friday.
Thank you. Now, based on your experience, either Mr. Reid or Dr. Cooney, how many should you have in order to run Banksia in a way that you believe it should be run?
The full staffing complement for YCOs is 65.
Right.
And we have, on most days, a full number of public servants in relation to the FTA that we have there.
And so in respect to the youth custodial officers, you're at about half what it should be.
On some days, yes.
As a consequence of that I presume limits the ability to provide detainees with opportunities to engage in various activities. Is that correct?
It does make it challenging.
Well, it makes it more than challenging. It makes it impossible on some days, doesn't it?
Well, we make it work. I've got some statistics since the 20th of July in relation to the services that we provide there and the impact of moving the most acute detainees out and the increase in services that we provide and the decrease in critical incidents.
I'll come to that in due course, the question of moving to Casuarina. But as it currently stands, in relation to youth custody officers, you appear to be, on average, working at about half the ideal number.
It can be on some occasions, yes.
Well, there's no occasion when 65 turn up, is there?
No, but there is occasions where we've been over 40 as well.
Well, over 40 is still a long way from 65.
Regardless of the number, we concentrate every morning on providing education and meeting all the essential services for the detainees at Banksia.
Is it the same situation in relation to Unit 18, that the number of staff, and I won't go through the numbers with you, is less than you would ideally like?
That's not correct.
You're happy with the staffing at Unit 18?
Well, at the moment, managing both facilities as superintendent, I have to spread my staff over both sites. We ensure on a daily basis that Unit 18 is prioritised.
And so, as the manager of both facilities, you choose to give preference to Unit 18 in terms of staffing. Is that right?
I wouldn't use the word preference. However, Unit 18 has some acute needs, and it's important that the needs of those detainees are met. Because those detainees are at Unit 18, Banksia has become a more settled environment, and I'm able to provide education and a range of other services such as programs and daily routine more routinely than I could previously.
When I say you give preference, you indulge, I suggest to you, in a triaging process of working out where you believe those staff would be best utilised.
There's a designated number of staff which would be a full complement at Unit 18, and wherever possible, we maximise those numbers and maintain the security and safety of both sites.
During your time as Superintendent of Banksia, what has been the turnover rate of staff on an annual basis?
In relation to youth custodial officers specifically, to the middle of October, there is 61 new staff have been trained during this year, calendar year, and there's been 47 staff that would have either resigned or retired.
But prior to this year, what was the situation? The reason I ask this question, Mr. Reid, is not attempting to trap you. It's just that a number of statements we've received, both from families and from government witnesses, constantly refer to staff shortage as an explanation for certain things. And I'm trying to get clarity as to exactly what the dimensions of the staff shortage are. And one of the factors is being suggested that there's a very high attrition rate of people working within Banksia. So you've told me how many you've trained, 65 new staff trained this year.
61, I think.
61, sorry. And I think you said 47 that retired?
Of October, yes.
Yeah. What about prior to 2022? What was the turnover rate of custodial officers?
I don't have that turnover rate available to me. As mentioned, I was there since the 1st of November last year.
When you said that 47 had retired or resigned, that's not 47 out of the 61. That's 47 of the complement of the officers who held positions.
That's correct, yes.
Yes, all right, thank you.
You also indicate in your statement some information in relation to detainees with disabilities at paragraph 20. As of the 30th of August 2023, 33 detainees, all boys, had disabilities. 26 were First Nations. That's correct?
Yes.
Would that mean that over a third of the average number of detainees in Banksia had disabilities which had been identified,
That's my understanding, yes.
and that nearly 80% of detainees at Banksia are First Nations young people.
Yes, it can fluctuate, but it's quite often 70% or higher.
Do you know what the youth population of Western Australia is as split between First Nations and non-First Nations young people?
No,
Do you know Dr. Cooney?
No, I don't, but I know that we've got a significant overrepresentation of First Nations people in Banksia Hill.
In designing the programs you're involved with, Dr. Cooney, do you take into account the gross overrepresentation of First Nations young people?
We do, so all the programs that we source or provide comes from a lens of cultural appropriateness and also targeting or applicable appropriate for young people with significant impairments in one or more domain.
And do you bring in First Nations people from outside to assist in any of those programs?
We do attempt as much as we can. So we've got a number of programs that are provided by Aboriginal controlled organisations, but also we've got a number of staff on site as well who provide assistance. So people like the Aboriginal Youth Support Officers and AVS, so the Aboriginal Visitors Scheme as well, and some visiting elders.
Can I presume that the Aboriginal Youth Support Officers and Aboriginal Visitors Scheme people are First Nations people?
Yes.
What percentage of the rest of the staff working at Banksia are First Nations?
I don't have that statistic.
Do you know, Mr. Reid?
I don't have the statistic with me today, but we do have a representation of First Nations staff, yes, in the custodial roles and across the site.
Well, I won't hold you to a figure, but what's your best guess as to the number of First Nations people amongst Banksia staff?
If it's in the entirety of all staff, I'll make a guess and I'll say 10%.
And how many of those are in senior management at Banksia?
None at this stage.
Do you regard that as an issue that needs to be addressed, given the fact that 80% of your detainees are from that group?
Representation in relation to First Nations is important, and that's why we have dedicated roles such as the Aboriginal Youth Support Officers, and which is amplified in the fact that that service is about to be doubled in relation to its staffing numbers.
I wonder if you'd be good enough to answer Mr. Griffin's question. Do you regard that as an issue that needs to be addressed, given the fact that 80% of your detainees are from that group, and the issue was the proportion that are in senior management, and your answer was none? So that's the issue you were asked to comment on.
That's correct, and positions in senior management are gained through a process of application and interview. And if they're not a 50D position, it's open for the best applicant to get that role. Do I think it's a good thing for people from First Nations to be in senior management roles? Absolutely.
Do you accept the proposition, Mr. Reid, that perhaps a more specific approach would need to be taken to breach this apparent ceiling, which results in no First Nations people being in senior management, as it has been done in the general community in many areas?
The Department of Justice has a policy in relation to First Nations people and employment. That's my understanding.
Yes, I know they've got a policy, but in respect to the question I'm asking, it doesn't appear to have had any success. And I'm asking you, I think you've said appointment is based on merit, correct?
That's correct.
If that process hasn't to date produced any First Nations senior manager within Banksia, what steps could be taken to redress that imbalance?
I think the identification of that issue at first is an important thing as you're identifying, and considering that in the process of whether in the management structure a position needs to be specifically made to be 50D to complement that.
Do you accept that, as a general observation, change is assisted if people can see people like themselves in positions of authority? If one of your 80% of Aboriginal detainees could see an Aboriginal person in management, that could have a significant effect upon the unit. Do you accept that proposition?
Yes, I do.
And do you say it's a matter for the department and its programs to deal with that? That there's nothing you can do at your level?
Well, I obviously have input into the shape of the management structure at Banksia, and
You do, but how do you have input? What have you said and to whom have you said it?
well, I'm aware that there's $3.5 million being committed by the state government to expand the Aboriginal youth service. And I think that's a great opportunity for Banksia to employ those First Nations people into that role and look at how my management structure works with that increase in staffing.
Would another approach be to upgrade the designation of existing First Nations workers within Banksia,
Yes.
including upgrading a position into a management level position?
Yes, that's correct.
Well, would you support such an approach?
Absolutely.
Have you suggested that approach in the past?
Yes.
What happened to your suggestion and to whom did you make it?
Well, at the moment, the funding that has been supplied is for additional Aboriginal youth support officers, not for a management role at this stage.
Mr. Griffin, ask a question. Thank you. I just wanted to ask a question, you may not be able to give it now, around the attrition rate of First Nations employees within Banksia Hill, and for a period of time. I know that you've started in November last year, but what is that attrition turnover rate, given you mentioned around 10% is the workforce? I also understand through my previous experiences that having senior positions in management which have a male and a female First Nations person working together, so not just a single person, but two significant leaders in management, is also critically important, particularly if you have both young men and young women, young children who are male and female. So that idea of culturally safe leadership, your feedback on that idea, or if that's been considered in the past?
It has been in general discussion in the time that I've been there. It has not been implemented yet, but I support the concept, yes. In relation to the earlier part of your question on what might be the attrition rate, I don't have percentages for attrition rate of the First Nation staff. However, I'm cognizant that there is several YCOs in particular that have been in the job, some up to 25 years, and over a fairly good representation of people who've maintained themselves since the opening of Banksia.
Thank you. Just one final question. Often in workplaces, Mr. Reid, exit interviews are voluntary. Is that the case there in Banksia? It
is, but we do go through and get information in relation to exit interviews and provide data to my directorate into reasons people have supplied where they've left our workforce.
And obviously that includes the First Nations employees that we're talking about now.
Yes, they would be in that mix, yes.
Thank you very much.
Can I come back to you, Dr. Cooney? You mentioned in an earlier answer that what you do is done through a lens of cultural appropriateness. you recall that?
Yeah, that's what we attempt, yeah.
What does that mean in practice?
So basically, we're looking for programs that are culturally appropriate and also programs that help foster cultural identity for the young people. So some of the programs that we've had in the last year, for example, we had a Noongar language program that was facilitated on a number of occasions. We've had some programs that involve music and dance, like the didgeridoo, etc. But then also things like the Aboriginal Rangers program comes in. So essentially we try and target specifically cultural identity, but then also all of the development of our programs the programs are developed bearing in mind that people may come from diverse backgrounds.
And what do you understand the term cultural safety to mean in relation to a First Nations child, particularly one with disability?
So my understanding would be that essentially the cultural identity of that young person is supported and encouraged and fostered.
And are you trying to build that cultural competency and safety within staff members at Banksia?
We are, yes.
Would not that be enhanced if there were more First Nations people employed at senior levels within Banksia?
Yes, most definitely.
Because you would accept, would you not, that there's a distinction between running programs on the one hand and what the detainees see and experience every hour of every day whilst they're there.
Yes, and what Mr. Reid has touched on it, there's been a lot of work done over the last 12 months to try and bolster some of those supports, but also positions. So like I said earlier, we have had 4 Aboriginal Youth Support Officer positions, and we've received funding for an additional 4. As well as some Aboriginal mental health and health staff. So that was all committed by Treasury. And through those discussions, we're still in the process of developing what the management structure for that Aboriginal unit will be. But part of that has been the consideration, like Mr. Reid said, of having a specific management position that will oversee those positions and, I guess, cultural activities across the site.
When can we expect to see that position created?
The discussions are ongoing. We've started recruiting for the Aboriginal Youth Support Officer positions, those additional 4. And we're in the process of working out what the best model is for the health positions, whether that's hiring staff, for instance, or using external health organisations. In terms of the management role, that's probably a question not for me. I'm not sure where we're at with that right now.
Who do you understand is ultimately responsible for making that decision?
I can make business cases as superintendent through the Women and Young People Directorate to be considered. Above that by Commissioner or Director General.
Yeah. So would Mr. Reynolds be in a position to make that decision, for example?
The delegation for creation of new positions may sit with the Director General or the Commissioner. I can't recall exactly.
So they're questions I could address to Mr. Reynolds or Dr. Thomason.
Correct. However, I am able to make business cases in relation to the site if I feel that there's a need for something, and I do on occasion, yes.
Have you made a business case to your superiors for the inclusion of First Nations people in the senior management of the unit?
Because we're at the stage of recruiting Aboriginal Youth Support Officers, and that process needs to occur, I have entered into, at this stage, verbal discussions to discuss how we can get the best outcomes for First Nations people, how those positions relate to the existing management structure, and or do they need an additional management structure within Banksia to complement business plan and measure the outcomes for First Nations people in Banksia.
I appreciate your answer, Mr. Reid, but is the answer to my question, no, you haven't made a business case for an Aboriginal person to be in senior management?
No, I haven't.
When can I expect you to make
Sorry,
that?
Mr. Reid wanted.
I'm sorry.
Wanted to add something. Yes, Mr. Reid.
Yeah, but I have held verbal conversations floating that idea, because obviously it needs support above my position.
Mr. Reid, do you happen to know what the operating surplus was for Western Australia's budget in 2021-22?
Look, I've heard it in the media, however, I don't recall any figures.
Does the figure of $5.7 billion refresh your memory?
As I said, I don't recall an exact figure, but I'm aware there's a surplus.
I think you can take it from me, based upon a document produced by the Western Australian government, that it was in fact 5.7 billion, and in 2022-23, 1.6 billion surplus is expected. Yes.
You indicate in paragraph 49 of your statement, Mr. Reid, that there is no dedicated Banksia Hill policy for the support and treatment of detainees with disability and cognitive impairment. But you go on to say that there are various policies that touch on this issue. Upon reflection, do you think there should be a specific policy dealing with those issues?
But yes, policy can be a good thing if policy carries out effective function. I need to ensure, from my perspective as someone who manages that detention centre operationally, that all of my processes identify, wherever possible, any disabilities and refer to appropriate services, and have either appropriate services on site or in reaching, or that they connect with community youth justice services.
So, do you support the creation of a dedicated Banksia Hill policy for the support and treatment of detainees with a disability and cognitive impairment?
I'm not sure that's a question that is one that I should be answering. For me, as an operational person running Banksia Hill, I have operational functions to carry out. If that policy would complement my operational efficiency, then the answer would be yes.
Well, it wouldn't hamper it, would it?
Depends on the content, but I don't expect any policy to hamper.
Well, if you have a policy that currently hampers your ability to do your job, you would tell people that, wouldn't you?
A policy, to my understanding, is always developed with best intent and outcomes.
Can I ask you, Dr. Cooney, the same question? Would you be assisted in your work by a dedicated policy of that type?
I had a similar reflection as I was putting together the information for this hearing, in that I had to look at multiple documents to find the information. So to have it all in one location seems to me that it would make sense.
It makes sense because if somebody has a single document they can go to, there is a greater chance that they will be able to understand and implement it, isn't there?
I believe so, yes.
It would, in fact, I suggest to you, increase operational efficiency, would it not?
Yes, and I think it would assist us in identifying any gaps that we may have as well.
Can I ask you about the training of staff working at Banksia Hill in respect to identifying and dealing with people with disability? Firstly, you, Mr. Reid, what particular training, if any, is provided to people coming in to work in the unit?
Particular training, sorry, did you say in relation to disability or generally?
Disability.
As per the response in my statement, item 47, and actually beginning at 46, it deals with a module 1 that talks about what is a disability. It covers the types of disabilities and how to identify someone with an intellectual disability or cognitive impairment. Then it goes over communication modules that relate to that. breaking into 47, which talks about trauma-informed care, and then it's got a wide range of teaching points that follow on from there.
The training in relation to disability awareness occurs at the Corrective Services Academy, correct?
Yes,
And that's limited to 3 hours.
there is a 3-hour module, yes.
And there's no provision, is there, for updating that training once somebody comes and starts work? Is that correct?
Not necessarily. We have a range of training that we provide on site almost every week at Banksia Hill, predominantly on Friday mornings. And we are just right now actually developing a training needs analysis. So staff have ongoing training in relation to a whole range of things at Banksia after they've arrived.
But if you take someone that applies to work at Banksia and they go through the academy training, they might be coming from zero understanding of disability, and then they're given 3 hours and away they go. That's right, isn't it?
There is other training in relation to specifically FASD. There's quite a wide range and suite of training that is ongoing.
So is there anything you want to add to what's outlined in your statement as to training?
No, I think it's quite comprehensive in there.
Dr. Cooney, is there any training that currently isn't provided that you think would be useful for the work you undertake?
So training
of staff, I should say.
I think a lot of the additional training, so there's the original training packages, but then there's a lot of specialists who work on site, and through consultation around individual young people, we find that there's a lot of information sharing there, and that can really bolster the operational staff's understanding about disabilities and the application of strategies around that. So I think more capacity for those staff to provide that increased consultation rather than a formalised training package, I think, is where we see the most benefit.
Training provided by the Corrective Services Academy, is that always face-to-face?
Yes, I believe so, yes.
It is, yes.
And I take it the training within Banksia is face-to-face?
Yes.
Yes.
What do you do to satisfy yourself that people attending training within Banksia understand what you're attempting to teach them?
Well, each of the training packages would have skills activities, as outlined in the statement from Mr. Reid. So there's typically kind of mini tests of learning along the way and the application of the knowledge. It's not, all of these trainings are not lecture format. It is really more about application of knowledge.
And is the training we're referring to within Banksia, is that compulsory for staff members?
Yes.
In every case?
If they're listed to attend training, the expectation is that they attend the training, yes.
Right. Who decides who should attend the training?
We have a training senior officer who conducts a schedule of training, and they keep records of staff training records, identify those who need to do a particular area. So
a custodial youth officer is the equivalent of a custodial officer in the prisons, is that right?
A training coordinator on site.
No, I understand that, but if you employ at Banksia a custodial youth officer, a CYO, is that right?
YCA, yep.
YCA, a youth custodial officer?
Mm-hmm.
Do they have the same general role as a custodial officer, prison officer in a prison?
Well, they're different roles and it has different training.
Okay. So what training is mandatory for your custodial officers in Banksia?
It's an extremely large suite of training. We go across things in relation to use of force and de-escalation, but I'll be rattling off a list which I can't recall all of probably over 20 and up to 30 different areas of curriculum.
Can I just finally deal with the transfer to Unit 18? 17 detainees were transferred initially.
Correct.
Is my understanding correct that some of those didn't come back to Banksia because they were otherwise released from Unit 18?
There has been some detainees that were domiciled in Unit 18 who have been released.
Yes.
And there's also, however, when they are going to be released, they're brought back to Banksia on that day to facilitate that release. And there has been some detainees that have returned to Banksia successfully and some unsuccessfully.
But the numbers at Unit 18 suggest that there are new detainees being transferred to Unit 18 that weren't part of the original group of 17. That's correct, isn't it?
Sometimes that is the case, yes. As of today, my understanding is that there's 10 detainees at Unit 18.
And of those 10 in Unit 18 today, how many of those were part of the original 17?
I don't recall that number off the top of my head, but detainees are assessed for consideration for transfer to Unit 18, as they generally, because they are presenting as a significant risk in relation to the security and safety of detainees and staff at Banksia Hill.
I want to explore that idea that there are significant risks to other detainees and staff.
Mm-hmm.
Who makes that assessment?
I have case planning staff that will develop that assessment, and the approval for that sits in my role.
And do I take it they're primarily assessed on the degree to which they haven't been compliant with the rules and regulations of Banksia?
There's a wide range of factors that are considered. In the end, I need to maintain safety and security at Banksia, and the benefit of Unit 18 has been significantly increased participation in education and programs at Banksia Hill since the 20th of July, and a significant decrease in critical incidents at Banksia. So if someone is providing a serious risk to safety of staff and providing a significant level of damage to infrastructure, and I'm unable through our planning and other processes to normalise their behaviour, then Unit 18 will be considered.
Well, it'll be more than considered. It's likely that's where they'll end up, isn't it?
Depends on the individual circumstances for the detainee.
But it's likely that's where they'll end up.
An assessment is made, and based on that assessment, I make a decision if that move is needed.
Mr. Reid, how many of the 17 that were transferred to Banksia had acute needs that required psychological or psychiatric intervention? My understanding is most of them. I think I looked today and I think the rate was about 80% of those were on the at-risk management system, but I would, in general terms, a high proportion have acute needs. But I thought we were told that anybody with high acute needs would be transferred to the EMU unit.
That's a separate matter. If they go to EMU, that's from prevalent and existing mental health issues that need management by mental health staff.
All right. How many of the 17 had mental health issues that required attention by mental health staff?
I don't have a number off the top of my head, but the transfer of these 17 detainees to Unit 18 were not exhibiting psychiatric mental health behaviours to the point where they needed to be considered for a mental health facility.
How did you know that?
They were assessed on the basis of the risk to Banksia Hill.
How does that tell you whether they have a mental health issue that requires intervention of mental health professionals?
A large range of, as we've already discussed, a large proportion of detainees at Banksia have a range of deficits, and that is reflected in the population at Unit 18 as well.
Yeah, but would you be good enough to pay attention to my question? How did you know whether the 17 or any of them had significant mental health issues that required mental health professionals to provide support to them? How would you know?
How would I know specifically they have mental health issues? Look, I don't look at every single individual's mental health issues every day when they're brought to my attention and it needs my intervention or my staff's intervention. then I deploy the right manager or the services to support that detainee.
But you were requiring 17 young people to go to the facility at Casuarina, Unit 18. Wouldn't it have been extremely important for you to know whether any of those 17 had mental health problems sufficiently serious to warrant the intervention of mental health professionals to provide support in relation to that condition?
The supports are mirrored in relation to health, mental health, psychological services at Unit 18. As part of the assessment, I would be advised if someone had mental health issues, whereas it made them unsuitable to be transferred to Unit 18, I would be advised of that in that process.
You would be able to produce, would you, the advice that you received for each of the 17?
Yes, that's correct. The quite detailed reports are completed for each.
Right. Well, I'm sure we'll ask for that. Thank you.
Mr. Reid, have you read the decision of the Western Australian Supreme Court in VYZ by next friend XYZ against the Chief Executive Officer of the Department of Justice, 2022, WASC 274, delivered on the 25th of August 2022?
Yes, I'm familiar with the outcome.
Have you read that decision?
I am familiar with the outcome and I would have read the decision.
Would you please answer my question? Have you read the judgment of the court?
Yep, if you allow me to finish, I had read it, thank you, back at that time, yes.
And you were the second respondent in those proceedings, correct?
Correct.
What is your takeout from that decision of Justice Tottle?
My take out of that is that the separate confinement of detainees was determined to not be legal as it was occurring.
Do you accept His Honour's decision?
Of course.
Why did that occur?
Why did the decision occur?
Why did the unlawful detaining of the detainees occur?
Since my time of arriving there, as we all know from our discussions, is 1st of November, it's been my responsibility to maintain the safety and security of the site. Between the infrastructure and the staffing, a range of restrictions have had to be put in place that are not ideal to manage for the safety of staff and detainees. So I can't recruit, unfortunately, a full complement of staff overnight. And although a significant commitment's been made by Treasury for infrastructure improvement, those things take time to be implemented. So maintaining safety and security is a daily battle.
There were three reasons I suggest to you, Mr. Reid, why the transfer was made to Unit 18. Safety of staff members, safety of other detainees, and to try and minimise damage to property. Would you agree with that characterisation?
Yes.
Can either you or Dr. Cooney throw light on what attempt was made to understand why the behaviour which was causing the damage was occurring in the first place?
So I can probably touch on some of that. So each young person who had been involved in the incidents, we do up a bit of a case formulation, which means that we try and understand their behaviour and pull together what the various factors might be that's impacting on that behaviour. So we look at individual characteristics of the young people who we know have high levels of trauma and disabilities. And then we make recommendations for staff on adjustments that can be made in their approach to the young people to try and support those needs. It was complicated by the fact that the low staffing and the infrastructure weaknesses, the young people had identified those issues, and once they had spent periods of time in their cell, the boredom and lack of engagement and activities became a significant factor at play.
So there is an argument, a credible argument, is there not, Dr. Cooney, that the behaviour that caused some of these people to be transferred to Unit 18 was caused by the department's failure to adequately staff Banksia in the first place.
So it's a really complex issue that can't be simplified to that extent. I think there's a complex range of factors that are interacting that has led to the position that we're in.
But you can't discount that as being a primary consideration, can you?
I think one of the factors that was impacting on the behaviour was the time spent in cell, yes.
A very significant factor, I suggest to you.
It would be hard to put weightings on what the most significant factors were, but it was a factor.
If you keep a young person locked in a cell for 23 hours of the day, and that young person has relevant disabilities, that would be a major factor in assessing their subsequent behaviour, wouldn't it?
Yes.
And what I want to suggest is that that factor was not given sufficient weight, Mr. Reid, in the decision to transfer every one of that group of 17.
Staffing was one factor, but you would get no argument from me that young people being locked in their rooms would be a contributing factor. What caused one of the other significant factors that caused the move to Unit 18 was an involvement of the behaviour of young detainees prior to, back in 2021, they were not breaking out of their cells in the manner that they were in early 2022. So that situation evolved, and that was a significant factor where we could not contain people in their accommodation for the safety of staff or other detainees. That was a large part of consideration.
What it boiled down to, I want to suggest to you, Mr. Reid, is that the powers that be decided that the easier solution was to transfer rather than addressing the staffing and other shortages within the unit.
The staffing and recruitment drive had already been addressed well before the involvement of the behaviours where detainees were breaking out of their cells. However, to recruit, mobilise and train staff is a slow and lengthy process. We need to have our recruitment drive. There's assessment involved with that recruitment drive and preparation for the academy, then a 12-week course. And then it depends on the uptake across Western Australia where it was advertised on the numbers that you get on that course. So mobilising recruitment is unfortunately not as easy pressing a button, but yes, there's no argument from me that staffing has been a significant factor.
And there was another option, wasn't there? That trained staff already working for corrections in other facilities, adult facilities, could have been brought in the short term to address that issue. Correct?
That's not for me to answer.
But you've been in corrections for many, many years, haven't you?
That's correct.
And you know that it's not uncommon for staff in one facility to be transferred to meet an urgent need in another.
Yes, and there's been prison officers working already well before my time at Banksia Hill. And while I've been at Banksia Hill, I've had at least 2 or 3 recruitment drives asking for staff to volunteer and apply to come at Banksia Hill, and that has been occurring on an ongoing basis. But when you're talking about the whole of Department of Justice and other facilities, they have staffing needs as well. But I've had fairly good support in getting prison officers released to assist.
Chair, they're the questions I have for these witnesses.
Thank you very much. I'll inquire again of Commissioner Mason and Commissioner McEwen as to whether they have any further questions. Commissioner Mason.
No, thank you, Chair.
Thank you. Commissioner McEwen.
Yes, thank you, Chair. One question for either or both of you. The disability awareness training and the ongoing training relating to disability, is that provided by disabled people themselves?
No, I don't believe so. So the training providers differ depending on the training modules, but The training, the initial training about the disability awareness, that's provided by so the Department of Communities, so the other government agency. They've got a disability services team that are made up of, it's a multidisciplinary disability justice team that includes psychologists, speech pathologists, occupational therapists, but I don't believe that they have anyone with a disability as part of their team or as part of that training.
Why not?
I'm not sure that I can answer on behalf of the Department of Communities, sorry.
All right, but do you believe, though, that the training should be provided by disabled people themselves, relating if it's about disabilities?
I think any development of such training would be useful to have some lived experience contributing to that or present and providing the training, yes.
Thank you.
Mr. Reid, may I ask you whether you agree with the following statement? Confining detainees to their sleeping quarters or cells for long hours is a severe measure. Confining children to their sleeping quarters in a detention centre for long hours, thus effectively confining them in isolation, can only be characterised as an extraordinary measure, one that should only be implemented in rare or exceptional circumstances. Among the many reasons why it should be so characterised is because of the very significant harm such confinement can do to children in detention, many of whom are already psychologically vulnerable. Do you agree with that?
Yes.
I should say, to be fair to you, that the judgment from which I just read makes the point that no personal criticism of you was made in the judgment or was sought by the representatives of the applicant. Dr. Cooney, I don't intend any disrespect by this, but I notice you've been referred to as Dr. Cooney. Where does the doctor come from?
So I've got a Doctor of Psychology degree.
I see. Thank you. So that's a graduate degree that is actually the equivalent of a doctorate of philosophy, or is it a different?
So it's a professional kind of slight differences, but essentially it's a overall 6 years of studying in the field of psychology. It's a Doctor of Psychology, and the Doctor of Psychology differs from the PhD in that it's got additional practical components rather than, and a smaller research, whereas the PhD focuses more on research.
Well, thank you for that. I asked because I don't think it was referred to in your statement of qualifications, and I was just interested in the background. Thank you. In your answers on the program that included rehabilitation, I rather took it that the measure of, the intention of the program is primarily to reduce recidivism among the detainees at Banksia Hill. Is that a fair characterisation?
Yes, so in response to that question, yep, my role is to focus on providing as much as we can in the areas of rehabilitation.
My point is, I'm not talking about your subjective intentions. I'm talking about the intention of the program. It is to reduce recidivism. That's its primary purpose, is it not?
Yep, so I think as a centre, so everything that we do is targeted toward reducing recidivism. A lot of the programs that we have are specific in that regard. And then some of the other programs that we have are really about enrichment and trying to provide enjoyable and fun activities for the young people. But as a whole, our intention for Banksia Hill is to focus on rehabilitation of young people.
Given that that is the intention, has it been effective?
I'm not aware of the statistics specifically off the top of my head. I know that we've had some success stories that we hear of young people who have gone on to do some really great things and not have further contact with the justice system. And then we do have other young people that unfortunately do continue their contact with justice.
But you don't know of any studies that analyse the success of the program by reference to the rate of recidivism?
Not off the top of my head, sorry.
Chair, can I ask one more question based on that question that you just asked? Because, as you know, I'm very interested in recidivism.
Yes, Commissioner Maisie.
Thank you. just wanting to know, is there a program where young people who have been in detention and, as you say, have gone on and made a life of themselves in the community, is there a program where they would come back and speak to detainees as a way of assisting them to reduce recidivism of current young people in Banksia Hill? Is there a program currently running with that type of model?
No, so we don't have a specific or formalised program of that nature, but we engage with ex-detainees ad hoc, and they will occasionally come in. So probably about 2 months ago, we had a young female come back and explain the progress that she had made. And then sometimes like football players who have been in Banksia will come back. So it's more ad hoc. So we definitely attempt to bring that in so that they can explain their journey and be an inspiration to the young people that are currently there.
Do you think that a more structured program, a timetable rather than an ad hoc, which seems every now and again, once in a blue moon, might have a beneficial impact on the young people in detention?
Yeah, I think it would be great. It would be good to look at that. I think there are complexities with that, just in terms of some young people not wanting to remember their past periods of time in Banksia. So we'd need to find the right young people and then support them. But yeah, it would definitely be something that we could look at.
Thank you.
Thank you very much, Mr. Reid and Dr. Cooney, for your evidence today and for the written material, at least Mr. Reid, that you have provided. We appreciate your assistance. Thank you.
Thank you.
I see, Mr. Griffin, that we're a little behind schedule.
Yes.
What should we do?
I was proposing to reduce the lunch break from 45 minutes to 30 minutes if it was acceptable. I think I can be relatively quick with Mr. Reynolds, but will be some time with Dr. Thomason.
All right. Well, it's now, what, 7 minutes to 12 Perth time, 7 minutes to 3 Sydney time, and Commissioners Mason and McEwen can work out what time it is in Adelaide. So if we resume at 3:25 Sydney time, 12:25 Perth time.
Thank you, Chair.
The Royal Commission is now adjourned. The Royal Commission is now in session.
Yes, Mr. Griffin.
Chair and Commissioners, I call Mike Reynolds to give evidence. Mr. Reynolds is the Commissioner of Corrective Services in Western Australian Department of Justice. He has provided a statement to this public hearing dated the 12th of September 2022, identification number STAT.0617.0001.001. The statement is in hearing bundle C1 at tab 60, and the attachments to the statement are at tabs 61 to 69. I understand that Mr. Reynolds has made an oath prior to the present time.
Yes, thank you very much. Commissioner Reynolds, thank you very much for coming to the Royal Commission to give evidence today from Perth. By way of explanation as to where we are all located, Commissioner Mason and Commissioner McEwen are in Adelaide. I am in the Sydney hearing room, as is Mr. Griffin, Senior Counsel assisting the Royal Commission, and I will now ask Mr. Griffin to ask you some questions. Thank you.
Mr. Reynolds, you heard me indicate that you're the Commissioner for Corrective Services. How long have you been in that role?
I was appointed in March of this year and have acted in the role since November 2020.
And you've made a statement dated the 12th of September 2022.
That's correct.
And you've responded to a request for information which is attached to that statement. Can I take you to that? Do you have a copy in front of you?
In the statement?
Yes.
Yes.
And can I take you in particular to paragraph 8 of the attachment MR1.
Yes.
You're asked whether there are any gaps or areas requiring improvement in corrective services data collection. And you commence the answer by saying, on an individual level, we are able to accurately identify where a prisoner presents with a disability and then also manage it appropriately. On what basis do you make that assertion?
Based on the advice I've been given from our doctors, from our health clinicians, from our psychologists, from our educators, that for each time we do an assessment when they come in, as Dr. Rowland outlined in her evidence this morning, we have quite a thorough assessment process on entry. So we are able to, quite accurately identify those problems and manage them appropriately. Where obviously the concern is being able to, out of our current system, get that information for the whole cohort to make those assessments of, how many we have with specific disabilities.
Can I assume from your answer that you listened to the evidence of Dr. Rowland earlier today?
Yes, I did.
Did you also hear the evidence of Mr. Reid and Dr. Cooney?
Yes, I did.
Whilst the Commission was sitting in Perth for 4 days, did you have a chance to hear any of the evidence given by witnesses during that session?
Very little, but I have read the transcripts for the majority of them.
And so you're familiar in broad terms with the evidence given by what we recall lived experience witnesses?
Yes.
Going back to paragraph 8, are you saying that for every prisoner in the state, you're confident you can accurately identify any disability that they have?
What I'm saying is for every prisoner and detainee in the state, we undertake assessments. I'm confident that those assessments are appropriate. And, as much as possible, we provide the appropriate supports. As Dr. Rowland said this morning, sometimes gathering that information and data is quite difficult, especially with detainees, as they spend on average 38 days in custody. And so many of them are in for very short periods of time. So being able to gather that data and do those appropriate assessments can be difficult.
Well, I want to draw a distinction between appropriate and accurate. When you say you're able to accurately identify where a prisoner presents with a disability, does that mean that they have to disclose the disability, or you have to have some other document which discloses it?
It could be both. So obviously self-disclosing a disability, gives us that basic information. And then our assessment processes try to gather as much of that data as possible.
And does the assertion in paragraph 8 also apply to detainees in Western Australia in youth facilities?
Yes.
You've heard, no doubt, that this commission has received evidence along the lines that someone coming into a prison or a detention centre may be reluctant to disclose a disability for various reasons.
Yes.
You wouldn't be aware of people that fit into that category, would you?
No, but our assessment processes try to use other ways of making those assessments: observation, medical assessments, psychologists and social worker interventions to try and identify those disabilities. It's often that people that come in on the early admission are often under the influence of alcohol or drugs or emotionally distraught. So it's very, very hard to determine that information right at the beginning of their admission.
But do you understand the distinction I'm drawing is between being able to accurately identify those prisoners that have disclosed disability as opposed to asserting that you know in relation to all prisoners whether they have a disability?
Yes.
And you certainly can't know the latter, can you, if they don't tell you?
No, that's correct. If they don't tell us and we aren't able to identify it through other assessments, then we wouldn't.
Were you involved in the creation of the functional impairment screening tool known as FIST?
No.
Who was primarily responsible for creating that tool?
My understanding, Dr. Rowland and her team.
You heard me ask her questions about the validation of that tool.
Yes.
Which currently hasn't been undertaken. Do you have any information about whether or not the department will fund an independent validation of that tool?
Once we have a reasonable data set, so as Dr. Rowland said, WEXA does this sort of stuff for us normally. They've, on a number of occasions, they've asked for more data. It's very similar with our drug and alcohol prison and unit, where there needs to be a reasonable percentage of data for them to do an accurate assessment. The department is absolutely supportive of assessing the data to determine the accuracy of the tool at an appropriate time.
We're currently approaching the assessment of 1/3 of adult prisoners. When will be the tipping point where that validation process can be undertaken?
I'm certainly not an expert in validation, so I would really need to get that advice from my colleagues who run WEXA, who are experts in providing that assessment and validation, to what percentage would tip the scales. But once I'm informed we have enough, we would undertake the valuation.
Mr. Reynolds, will you take that question on notice and ask the appropriate people to respond in writing to the Commission after this hearing?
Yes.
Thank you. I don't want to take you through the screening process which we discussed with Dr. Rowland in any detail. It's true, isn't it, that you rely upon her answers in respect to many of the questions you were asked?
That's correct.
In particular, in relation to people with disability and the support they receive when they're in custody, from paragraph 15 onwards, you outline the times when you rely upon the responses given by Dr. Rowland.
Yes.
I pick up one thing in paragraph 16. There's a discussion about transferring prisoners to the Franklin Centre.
Yes.
And it says, the likelihood of successfully transferring the prisoner to the Franklin Centre is very low due to the lack of beds usually available.
That's correct.
That's to your knowledge?
That's to my knowledge.
There are very few options left, and my priority must be to keep prisoners alive. We are unable to administer medication without consent, and often the only option in such circumstances is to place the prisoners in crisis care unit, the CCU, for their own safety. I recognise that this is often a non-therapeutic environment and results in a restriction of access by the prisoner to their usual activities.
That's correct.
What steps have you taken in light of that information to try and rectify the situation of beds not being available at the Franklin Centre?
So I'm aware there's a task force working on redoing the more beds at Franklin Centre. The Director General is probably best placed to speak about that because he's actually on the task force for that. But it's well known that not only in Western Australia, but in most correctional jurisdictions, we tend to be one of the biggest suppliers of mental health services. And it's very rare for, the community to have enough beds for those in custody who have a mental health issue. Access into Franklin or EMU is for the most critical, and it is really based on bed space.
Do you know, based on your experience, Mr. Reynolds, how many current adult prisoners are unable to be accommodated in Franklin due to bed shortage?
Look, that varies from time to time, but I'm aware we've got about 1,000 prisoners who are diagnosed with a mental disorder, and there's probably many more who have an undiagnosed disorder. Those are what we would call the critical or extreme Risk, probably around 30, but that kind of varies. Some of those could definitely benefit from a placement in somewhere like Franklin, but the health service triages those at greatest risk and moves them. What it unfortunately means is sometimes someone's sent back from Franklin back to custody earlier than would have been ideal.
So can I take from your answer, without holding you to precise numbers, that there could be as many as 30 adult prisoners today in Western Australian prisons who, on a medical assessment, should be in Franklin?
Potentially, yes. The most of those wouldn't be on a Form 1, which is the authorisation or the direction from the doctor to place them in a mental facility. But my experience from more than 3 decades working in corrections is there are many people in custody who would be better suited to being placed in a mental health facility.
How do you endeavour to manage those people within the prison?
We absolutely endeavour to manage them, and there's a range of processes and functions and supports put in place. At the top end, as I said in my statement, placement in a CCU under direct observation of staff to ensure their safety. But often it's just placing them in a unit that is, a quieter unit, less intense, getting them to buddy up with people who provide them supports. Managing in a non-clinical sense their behaviours at the time, and the staff, both custodial and allied services, are very, very focused on ensuring the welfare of these people.
Mr. Reynolds, is it fair to say that that approach is one of containment rather than providing treatment?
It's about ensuring their welfare. We're not in the position to provide medical treatment that they would gain in a mental health facility.
If that's the case, and your staff recognise they need acute treatment, and for logistical reasons they're not receiving it, isn't that a form of torture?
No, it's not a form of torture. I mean, we manage the people who are remanded or sentenced to custody by the court. As a correctional services, I don't have an option to choose not to take somebody into my custody. They are sent to us. We manage them as well as we can and in the most appropriate manner. I absolutely don't accept that we torture them.
Have you considered the option of placing such people in a secure inpatient mental health unit in the community?
Well, there are no beds or secure mental health units available.
And has that been the case for a number of years, in your experience?
Certainly my experience in the last 3 years in Western Australia, and the 32 years in South Australia, there are no large or appropriate mental health secure facilities in the community.
Let's confine ourselves at this stage to Western Australia in the last 3 years. Given this issue, what steps have you taken to try and redress that question?
It's not a decision for me to determine what mental health facilities are in the community. As I said, the Director General is sitting on the task force looking at the increase of mental health beds in Greylands and Franklin. But it's not for me to make a submission that I need mental health beds.
Well, can I beg to differ about that, Mr. Shepherd? It may not be for you to make the decision, but my question was, what steps have you taken to try and rectify that situation?
Sure.
Particularly since you've been the Commissioner.
So I'm fully aware that we have a mental health issue. My team talks to the Mental Health Commission on a regular basis. As I said, the Director General is on the task force looking at this very issue to try and find more secure beds.
But have you personally made representations to the Minister in your role as the Commissioner for Corrective Services?
The Minister is aware of the mental health beds, and it's been a discussion, but I have not made a personal representation to the Minister about getting more community beds.
Why not?
Because as far as I'm aware, this is already being dealt with through the revamp of the Franklin Centre and Greylands.
What's your understanding of when the Franklin Centre will be revamped, to use your word? What's the deadline for that?
Again, Dr. Thompson's probably the best person to give you those dates because he's actually on the task force. But it's a large initiative to increase. Dr. Thompson and I have discussed it on many occasions, and he's been clear that there needs to be many more beds for those in our custody who require secure mental health treatment.
Subject to correction, I thought I read somewhere where it was anticipated it might be 2026 before that happens.
Well, that may be correct. I mean, building a new facility doesn't, or extending a new facility doesn't happen overnight.
So do the people that can't get access to Franklin just suffer for the next 4 years?
We do everything we can to give them appropriate support whilst they're in our care. If they're floridly psychotic or violent, we'll take them to an emergency unit at a hospital to provide support. But as Dr. Rowland said, we're not in the position to be able to administer medication or those sort of treatments that they would get in somewhere like Franklin.
You're responsible ultimately for the management of Banksia Hill Detention Centre.
Yes.
How would you describe your level of satisfaction with how that centre has been run over the last 2 years?
Banksia Hill's been a very difficult facility over the last 2 years, and as others have already said, part of that was due to the low staffing numbers. We also have a very difficult cohort of young people who have come into custody, and we're seeing very similar behaviours that have been enacted by those same young people in the community, where there's high levels of violence, high levels of destruction. And Banksia, the infrastructure was developed 25 years ago, and it was fit for purpose then. Since then, we've had major damage, major unrest. If you're asking if I'm satisfied if Banksia is all it could be, absolutely not. But we are doing everything we can to return it to a normal operational model and have the young people who aren't involved, especially those who aren't involved in this destructive behaviour, having the best chance of getting supports and rehabilitation.
To use your words, when was Banksia last a normal operational model?
Banksia is working on a relatively normal model now, and was prior to probably February this year, where we started to see the level of destruction. But we have had a lot of staff shortages and damage over the last 18 months in that facility.
So do I take it from that answer that as the Commissioner, you're satisfied with how Banksia was operating up until February this year, and you're currently, subject to staff shortage, satisfied with how it's operating?
No. Basically, what I said is you asked when it was operating normally. It was operating normally. I've been very clear with my position on Banksia that we needed to review the model of care, and we needed to have a different focus at Banksia. There's been a number of different models of care put into the system that frankly don't work. They weren't consulted widely with the staff or the young people. So we've done a full jurisdictional scan. We've looked at youth custody experts. We've engaged them. We focused on developing a new model, and that's the process of what we're in. So it hasn't worked the way I wanted it to work since I've been in this role, hence the focus to change the operations.
So when you say it was operating normally up until February this year, does the word normally mean adequately in your view?
Normally means how the approved model of operations was at that stage.
Right.
But I wasn't necessarily satisfied, and I wanted to give the young people in custody and the staff who work there the best possible chance of success.
So as of February this year, what aspects of its operation were you not happy with?
We had a high range of damage and violence against my staff and damage against the facility, exacerbated by a number of resignations and shortages of staff, which was impacting on all of the young people. So they were secured a lot more than I was comfortable with and not able to have access to the normal operations of the centre and all of the activities.
Do you read the reports of the Inspector of Custodial Services when they're published?
Yes, I do.
Does you as Commissioner or the department more generally respond to each of the recommendations made by the Commissioner within a timely fashion?
Yes, we do.
How do you do that?
So we have an MOU with the Inspector. So we get a draft report prior to his tabling, which we can provide, I guess, opinion and support on if we disagree with something in the report. We will then determine whether we accept the recommendation, whether it's current practice or whether it's something that we don't agree with. We will then provide that back to the Inspector formally within a number of weeks after the report being sent to us.
No doubt I've heard Banksia described as being not fit for purpose. Do you understand what that expression means?
Yes.
Do you accept that proposition?
I accept that the purpose it was originally designed for is not what it's being used for now. And we are modifying the facility. The government's given us $21 million to make modifications to make it fit for purpose.
What changed between when it was first established and now, which rendered it, in your view, currently unfit for purpose?
So the change, I didn't say it was unfit for purpose, I said we're making it fit for purpose. So there are areas in it that aren't ideal, and that's why we're not holding them. That's why we've had so much damage. When the unit was first opened, it was opened as a sentenced prison for detention centre for detainees who were sentenced, and it was an open campus, almost like a school design. With the closing of other detention centres and amalgamating all into one facility, it became everything. So a remand facility, a sentence facility for young people from the age of 10 to 18, and both male and female.
So when it was a facility for young people who'd been sentenced, it didn't have difficulties in relation to staff shortages?
Look, I couldn't really comment. As I said earlier, I wasn't in the state at that time, but my understanding is they didn't have those issues.
And there was no significant issue of damage to property?
Again, I believe not, but I couldn't confirm that because I wasn't here then.
And so when remand detainees were included in the population at Banksia, did that change the unit in some way?
Well, my understanding is that when they combined the two units, there became a level of disruption.
Where's that understanding come from, and precisely what were you told?
From advice I've had from talking to management from Banksia and staff who've been there for a long period of time, who had said that it was more stable when it was just a sentence facility, had much lower numbers, and the combining of the remand and sentence created different issues.
It's not clear to me, Mr. Shepherd, why it would make any difference whether someone was sentenced as opposed to remanded, in the sense that you're drawing the distinction.
Sorry, it's Mr. Reynolds.
Sorry, Mr. Reynolds.
Sorry, could you repeat the question?
It's not clear to me why you draw a distinction between sentenced young people and remand young people as causing a different consequence for the management of the unit?
So it's quite often that persons on remand are a lot more unstable. They often come in highly emotional because they've been sentenced to custody or sent to custody, whether that's prisoners or detainees. They often have a lot of issues that you wouldn't necessarily get with a stable sentence population, i.e. drug, alcohol issues. There's often family concerns, access, if you're an adult, access to your children and other things. So the remand population is always less stable than a sentence population.
I'm afraid I still don't understand why you say that. Where's the research to support the proposition that remand population is more unstable in the way you've described than a prisoner population?
Well, I mean, I can't refer you to direct research, but I can refer you to 35 years working in the industry. And I can tell you that in my experience, a remand population is always less stable than a sentence population of prisoners.
Is it possible that that lack of stability has something to do with the way they're treated?
The lack of stability usually, Commissioner, is based on those other triggers. They don't know how long they're going to be in custody. They don't know what's going to happen. They have, family and friends. Those social contacts that are changed. Often they have simple things as pets in the household. People picking up children from school. There's a lot of other stresses. They've got the court process. They've got the court case. They've got, am I going to be sentenced? And am I going to be, am I going to get a long sentence? Am I going to get a short sentence? So the remand population always has, I guess, a high level of stress on them than a sentenced prisoner. A sentenced prisoner knows how long they're going to be in custody. They know what the progress is, how long they're going to be in sort of maximum security, how long they'll be in minimum, when they'll make it to maybe a work farm, whether they can get work in the community. Their time in custody is mapped out for them. A remand prisoner, it's sort of from court hearing to court hearing. They never really know what the outcome is.
How many of the 17 who were transferred to Casuarina were on remand?
I don't have that number off the top of my head. I think it was probably about 70%, but I'd have to confirm that.
Can I ask you in relation to a report from Mr. Ryan, the inspector, where he made a recommendation in relation to the screening, and he suggested that revise the initial health screen to include identification of intellectual disability and cognitive impairment. Are you familiar with the detail of the screening which occurs when people enter Banksia?
I've been briefed on the screening, but I'm not intimately involved in obviously the medical side of the screening.
Well, both Mr. Ryan and his predecessor, Mr. Morgan, commented in reports on the inadequate process for the identification of cognitive impairments in young people in custody. It appears from the evidence the Royal Commission have that this issue was not promptly addressed. Do you have any information in relation to that issue?
No, my understanding is that, and from Dr. Rowland's testimony earlier, that the assessment process that we use is covering most of those issues.
Did you hear Dr. Rowland's evidence in relation to access to pre-sentence reports?
Yes, I did.
Do you agree with what she said about what the understanding was at particular times about whether access could be gained to those reports?
Yes, I believe there was opinion sought in 2014, which made it more complex. I think there's a better understanding now about how access. I think when Dr. Rowland spoke this morning, she spoke about access to the reports in the Youth Sentencing Act, which is different from the Adult Sentencing Act. But I understand that we do have solutions to ensure that they have access to both where appropriate.
Well, you would have heard me take Dr. Rowland to the provisions of the Act. And on my reading of the Act, the entitlement has been there for quite some time under Section 4A. Were you aware of that?
No,
Were you relying on advice which had been provided by the Crown Law Department or some similar body in 2014?
that's the understanding. That was the advice that they were working off. And as I said recently, they found that they actually were able to get access.
Well, when you say recently they found, I was unaware of this legislation until recently, and I simply looked it up and immediately came to a view, as I indicated this morning. Why was the department not advised of what the effect of subsection 4 small a was?
I don't know, I can't answer that.
Well, isn't it intrinsic to a successful screening and assessment process that you have access to as much relevant information as possible?
Yes,
And a specialist report included in or attached to a pre-sentence report would usually be such information?
that's correct. But the advice we had at the time was we couldn't access them. We now understand that we can, and are you going to use them?
Well, I take it you don't have legal qualifications.
That's correct.
Can I assume Dr. Thomason doesn't have legal qualifications?
That's my understanding.
And yet you share certain things in that he's delegated to you what was his statutory role as Commissioner in relation to corrective services?
Sorry.
Dr. Thomason was appointed Director General of the Department of Justice.
Yes.
He also was effectively the Commissioner for Corrective Services. Is that your understanding?
He's the Director General of Justice, and
Yes.
he delegated responsibilities to me as
Yes.
the Commissioner.
And so one of those delegated responsibilities was your role as Commissioner for Corrective Services.
Yes,
Neither of you are legally trained.
that's correct.
Where do you obtain legal advice from if and when you require it?
So there's two avenues. One is through the State Solicitor's Office, and the other is through the Legislative Services Branch in Justice.
Right. And presumably Legislative Services in Justice would have been aware of the Act when it was amended with the inclusion of 4 small a. That'd be safe to assume, wouldn't it?
I'd assume so.
Because it's legislation directly concerning the department.
I would assume so.
And are you saying, to your knowledge, you were never advised that they had looked at that new section and given advice about what it could be used for?
That's correct. I was not advised. Again, I don't know what they were or weren't aware of.
You'd have no problem with the notion that such information would come under the general heading of assisting in the management of a prisoner?
Absolutely.
And I take it you would be ready to use such information if it was relevant to a particular prisoner or detainee?
Yes.
And not being aware of the right to have access to it has presumably affected the ability of those running the prisons and the detention centre to assist some of their people in custody.
That'd be fair to say.
Do you have any explanation as to why that happened, that a power would exist for so long and not apparently be utilised?
No, I don't have an explanation for it. It's definitely not ideal. It's something that I'll definitely follow up. But we weren't aware, as Dr. Rowland had stated. We should have been, and we will rectify that failure.
Did you first become aware of what I've been speaking about today?
Yes.
Have you ever had occasion to look at the Sentencing Act?
It's not an act that I spend a lot of time looking at, Commissioner. Obviously, you know, I try and make myself aware of all legislation that covers the responsibilities of my role, but I'm not a lawyer, and I don't read sentencing acts line by line or other legislation, but I do seek advice from you know, legislative services or state solicitors where I need specific advice.
Yes.
You heard me ask questions of Mr. Reid in relation to the staff shortages. Do you agree with his answers in respect to the broad numbers involved in staffing Banksia?
I have sought some more detail after Mr. Reid's testimony, in case you wanted some accurate details. So I'm happy to provide you accurate numbers if that's helpful.
That would be appreciated if you could. If you could tell me where the information came from and what the information was.
So the information came from my Women and Young People Directorate, who are responsible for Banksia, and they provided me the breakdown of youth justice officers, senior officers, unit managers, public servants, other government staff, teachers, etc.
Now, if you could have that information sent through to us, I won't take you through every aspect of it, but it seemed in relation to the youth custody officers that Banksia on average was working at about half of the number that they ideally should have. Is that a fair commentary?
That's correct.
Why has that been allowed to happen?
I think there was an issue in the way we were recruiting for youth custodial officers, and rather than having a strong recruitment program where we run a continual recruitment, we waited until there were vacancies. We had a number of vacancies, a number of resignations in quite a short period of time, which exacerbated the numbers. And as Mr. Reid spoke about this morning, our attrition rate is still quite high, and a lot of that attrition was during the period where we were seeing a lot of serious violence against my staff.
Let me pick up on the attrition rate. Does the department have an exit interview for those people leaving the department?
We have a voluntary exit interview, as I think was outlined by either Mr. Reid or Ms. Kearney. But it's a voluntary exit, and not all people who leave are willing to undertake it.
What percentage of people exiting as employees participate in an exit interview?
I don't believe the numbers are high. I think the last time it was reported at the corporate executive was probably only about 15%, but I'd have to confirm those figures.
15% of those people leaving the department choose to participate in an exit interview.
I believe they're at the right numbers, but we'll confirm those numbers.
Have you had any advice as to what would be a suitable percentage in order to draw conclusions from why they're leaving?
Oh, look, I'd love to see 90 or 100% filling out exit interviews. Some of the advice I've been given from corporate services is that some of the reasons staff haven't completed exit interviews is they found them difficult to complete. So they've done a piece of work to try and improve an online system so they can give their anonymous feedback when they're leaving. So we're hoping to improve the numbers of exit interviews that we actually do get.
What does the current exit interview actually entail?
It's a questionnaire which asks a range of issues, i.e., you know, are you leaving to retire? Have you found a better job? Are you unhappy with the employment? And then it'll ask questions about how you found the department to work for. You know, was it a supportive environment? Were there issues with the way you were employed, or the interaction with other staff, or, you know, with the job in general?
Can that be completed with complete confidentiality?
Yes, it's an electronic. It sits in our electronic system, and so staff can log on and complete the interview, and it's completely anonymous.
Mr. Reynolds, I don't understand why a staff member would find that a difficult process in those circumstances.
Well, again, I'm not going to try and ascertain why staff choose not to fill out an exit survey. The system is there. I guess that's up to the individual leaving a department to determine whether or not they wish to be involved.
I want to differ with you there in relation to that answer. Isn't it absolutely crucial to know why someone would decide that they don't want to complete an exit interview? Probably even more important than reading the ones that do.
Well, again, I have no ability to force staff to complete an exit survey. Our human resources area in Justice have tried to streamline the process and encourage more staff to be able to complete exit interviews, but ultimately the decision sits with the individual.
It does, but you could have a question which simply says, if you don't wish to complete this questionnaire, please tell us why.
Well, we could, but I'm not sure that would give us any value because there'd be a whole bunch of staff who likely wouldn't even bother doing that.
Well, that's an assumption on your part. You haven't even tried it.
Well, with due respect, I don't necessarily think that changing one question on an exit interview is necessarily going to give us what we need. I would much rather prefer to try and get staff to stay and ultimately, if they're leaving, find out why they're leaving.
In effect, what you're saying, Mr. Reynolds, is that you're quite content for 85% of the people leaving to not give you any indication about why they're leaving.
I didn't say that at all. There's nowhere I said I was content. I just said I didn't agree with the premise of your adding a question.
Well, you're content to the extent you don't want to follow it up.
Pardon me?
You're content to the extent you don't wish to follow it up.
Well, that's not true. As I said, our corporate services area are focusing on trying to improve the number of exit interviews that we get. I think that shows that we aren't content to just leave it, that we are very focused on trying to find out why people are leaving the department.
Have you offered people who leave or intend to leave the option of a personal interview with someone so that they can explain what it is that has led them to resign or otherwise depart?
Certainly, Commissioner, the line manager or the site manager at the location they work always has that discussion prior to them leaving to try and ascertain, one, whether we can change their mind. It takes a lot of time to recruit and train staff, so we're very keen to keep as many as possible. And, we always try and have those conversations. A lot of people will give you, quite extensive reasons why they are leaving and still won't fill out the survey. Others will say, yep, it's time, I'm retiring, I've got a better job, I'm off. But we
sorry to interrupt, but when you say that it's quite common for the employee who's about to leave to have a discussion with a supervisor, is there any record kept of the reasons given in the course of those conversations?
They're not kept in a formal way. Obviously, they're shared to try and get a picture of why people are leaving.
But they're not shared.
They're not kept in a formal. So there's not a formal record or report that's kept. But the information that's coming out is shared through our sort of leadership teams through the department.
Yeah, I just want to be clear about the evidence you've given on this point. I understand that it may be common practice for a supervisor to speak to someone who is about to leave with a view perhaps to trying to persuade them to stay or to understand better what issues they may have. But is it a standard part of that discussion for the supervisor to offer the option of an interview with somebody outside the line of responsibility of the individual who is leaving?
No, the conversation is always usually through the chain of command.
Well, wouldn't it be a good idea, if you really want to find out what people think and why they're leaving, to actually ask them in person through somebody who is independent of the line of command and who has the skills to have a discussion in confidence with that person?
Look, potentially it could be. It's something that I would need to talk to our, our human resources team who manage this part of the business for us.
Yeah. Speaking for myself, I can readily understand why people don't want to fill out forms. I hate doing it. I'm not leaving the department.
Mr. Griffin, can I just ask an additional question? Mr. Reynolds, just wanted to have it clarified in terms of the exit interview. Is the information collected, is it confidential? Is it de-identified? Because sometimes in a workforce or in a public sector, that does create some nervousness in people providing information to a department as they exit. But that process, is it de-identified so there's checks and balances so that privacy really is strongly protected? Thank you.
Yes, Commissioner, it is de-identified, so it's anonymised when it's completed, and then goes into a database, and then as part of corporate executive, I'm given the sort of the trends that come out of the whole of justice from those surveys. So there's no way to individually pinpoint one person and say, Mike Reynolds left because he said this. So it's very protected in that manner.
Thank you.
Mr. Reynolds, you would know from your experience in management that continuity of staffing is very important.
Yes.
It enables people to understand the culture of the institution, correct?
Yes.
It enables them to bring to bear their experience in dealing with day-to-day issues.
Yes.
Mr. Reid gave evidence about the turnover of staff, and I think the figure can be as high as 25% on an annual basis. How do you know that you're not losing potentially the best people?
I think we may be losing some very good people. That's it's been very unfortunate, and that's why I've committed to doing everything we can to retain staff and give them a safe work environment.
As the Commissioner, do you have the authority to transfer custodial staff from one place to another?
Only from prison to prison. I have no power to transfer prison officers to the detention centre because they are both employed under different legislation.
Does it flow from that answer that nobody has authority to direct prison officers to leave a prison and go to a detention centre?
That is correct.
Has consideration been given to changing that in light of the chronic staff shortage at Banksia?
So consideration will be done about how prison officers can still engage in a detention centre as part of the review of the legislation. But what we do is we seek volunteers who are prison officers to provide support and assistance at the detention centre, and we get as many of those as we can.
But it seems from the evidence of Mr. Reid that not sufficient numbers put their hand up such that the staffing shortage at Banksia can be eliminated.
Well, prison officers can't work as youth custodial officers because they're not trained as youth custodial officers. So all the prison officers can do is provide some specific support and free up youth custody officers to work directly with detainees.
Well, they could certainly undertake tasks, couldn't they, such as manning gates and doing security and those sorts of things.
Which is what we use them for.
Yeah. And that would free up youth custody officers to deal directly with the detainees.
Well, that's what we've done.
Yeah. But there still remains, on my understanding, a significant staff shortage at Banksia as we speak.
There is a staff shortage at Banksia, which we're addressing. However, even if I could transfer another 30 prison officers to Banksia, I still couldn't put them in frontline direct contact with the detainees because they're not trained youth custodial officers.
What exactly does one have to do to be trained as a youth officer?
Commissioner, they're very different roles. I mean, there's a whole different training.
I understand, but what does one have to do to be trained?
Well, if I wanted to train a prison officer, if I had prison officers who determined they wanted to become a youth custodial officer, we would send them off to a recruit course and give them the full 12-week training as a youth custodial officer.
So it takes 12 weeks?
Indeed. And if they're going in the other direction from a youth custodial officer to a prison officer, it takes the same amount of time. So we give them very different training, and we wouldn't, I can't see a situation where I could transfer prison officers in and make them youth custodial officers.
But you could inquire of prison officers whether they'd be interested in taking the 12-week course and thus having more skills. And we
have done that, and we've had very few take us up on that. But where they do, we actually will retrain them into the new role. Unfortunately, we tend to get more youth custodial officers who choose to go off and be prison officers.
Why is that? Why is it more attractive to work in a prison than a youth detention centre?
That's really up to the staff. The pay and conditions are probably different. It's something we've been working with the union as part of the next round of enterprise bargaining for youth custodial officers to look at being able to match some of the conditions that are in the prison officers agreement.
Sorry, can I go back to my question? Why do you believe it appears more attractive to work as a prison officer than a youth custodial officer?
Well, I think I just answered that. I'm sorry if it wasn't clear. I think a number of them think it's a better pay and conditions to work as a prison officer than it is as a youth custodial officer.
Well, let's deal with the pay. Why is the pay not equivalent for a prison officer and a youth custodial officer, if it is different?
Well, it is different. And as I said, we're working with the union and public sector as part of the new enterprise agreement for youth custodial officers to try and match some of those conditions.
Well, can I give you a tip? If you offer youth custodial officers an increase in pay to go up to the level of prison officer, you'll have to leave the doorway with the rush. What's there to negotiate? Make them an offer.
Well, with respect, I'm not in a position to make a pay offer to staff. It goes through the enterprise bargaining process, which we're currently involved in, and I've made very clear recommendations to both the government and the Youth Detention Officers Union that we should be seeking to try and match those conditions. So, what you've suggested is what I'm trying. But I can't just give them a pay rise because I think it's a good thing. That's not the way the public service works.
How long have these discussions been going on?
Since I've been in the role, I've been having this discussion.
Which is how long?
Since March this year.
And how far away are we from a resolution?
Well, the enterprise agreement is currently being worked on. An enterprise agreement is renegotiated every couple of years. So theirs is due. We're working on it now.
Mr. Reynolds, you could go to the minister today and you'd say, can the government make a temporary decision to pay youth custodial officers on the same rate as prison officers, pending the finalisation of the enterprise bargaining agreement? There's nothing to prevent you doing that, is there?
We've already gone to the minister on a number of occasions and sought extra payment for specific periods, which has been approved and supported by the minister. And so we are paying extra money to youth custodial officers where we can.
Well, what is the difference in pay for a youth custodial officer compared with a prison officer?
I'm not sure what the dollar value is. There is a dollar value, and there's it's very complex, Commissioner, because there's different conditions. So the prison officers have an annualised salary. The youth custody officers have different leave arrangements. So trying to balance out those things, because what I also don't want to do is take off benefits that the youth custodial officers have under their enterprise agreement. So it's not swapping from one to another. It's actually trying to match the conditions to give them, an equal footing to what the prison officers have.
Do they have separate unions representing them?
Yes, they do.
Mr. Reynolds, whilst this goes on, young people in Banksia are continuing to suffer by not being able to access the entitlements they should be entitled to. That's correct, isn't it?
Young people in Banksia are getting out of their cells, they're getting access to lots of support and programs and education, which has dramatically improved since the opening of Unit 18.
Did you read the decision of the Western Australian Supreme Court that I referred Mr. Reid to?
I did.
What was your take from reading that decision?
My take was that the court determined that placing young people in isolation due to staffing shortages wasn't lawful.
Did that decision surprise you?
I think that we may not have made the case that we should have. I think that it's a much more complex than just staff shortages.
Well, what are the other complexities apart from staff shortages that caused that to happen?
Incidents predominantly. Damage, violence, assaults against staff, rooftop ascents, damage to property, escaping from cells, to name just a number of incidents that regularly cause disruption to the day, and was much more so when we had the cohort of young people causing this level of damage.
Do you accept that at least some of those people that were causing disruption, that their conduct may have been attributable to their disability?
But potentially it could have been, but I also have a duty of care to...
I'm not doubting your duties.
Well, yeah.
Do you also accept the proposition that placing those people in confinement for up to 23 hours a day may have significantly contributed to their behaviour?
Long term of detention for any isolation for any person is not good, it's never ideal, and it would have definitely contributed to continuing of behaviours, but the majority of the young people who ended up being locked in their cells was because of the behaviour of others.
Well, you heard the evidence of Mr. Reid to the effect that an assessment was done in relation to each of the 17 that were transferred to Unit 18, correct? Who conducted those assessments?
So the assessments were done at the facility. They included a multidisciplinary team of staff, including custodial, psychs, health, education.
And were those assessments or reports reduced to writing?
Yes.
Did you receive copies of reports in respect to each of the 17 detainees?
No.
Who did?
So they were managed through the Superintendent at Banksia Hill and through the Deputy Commissioner of Women and Young People. I have seen them, but I didn't individually review each of the 17.
Do you know whether the Director General of the department reviewed those reports?
You'd have to ask him.
Do you know where those reports are currently held?
All of the reports for all of those detainees are as part of our permanent record management.
Do you accept that it was an extraordinary action to move young people from a youth detention centre to a unit in an adult prison?
I agree it was an extraordinary measure. I think it was a well-balanced and long thought out decision of the Director General, which I fully support, and had been options for other placements had been considered for quite some time, and initially we determined we wouldn't move them until we got to the stage where they're actually able to escape their cells and attack staff when we have minimum staffing at night.
And you supported Mr. Reid's decision without having seen the reports relating to each of those detainees?
Sorry, I don't understand. What are you saying?
Well, you're the Commissioner.
Yes.
I understood you to say that you relied upon the Superintendent of Banksia to make that decision about who to transfer and where to transfer them to.
Based on the multidisciplinary review, yes.
Yes. So he was the decision maker as far as you were concerned?
Yes.
It said elsewhere that Dr. Thomason was the decision maker on that issue.
No, in my understanding, and you can confirm this with Dr. Thomason when you speak to him, his decision was to seek the gazettal of Unit 18 as a youth detention facility.
Okay, I accept that. Why did you not become involved, and why didn't you make the decision about any transfers, given the extraordinary nature of what was being proposed?
I think it was more appropriate for the person who is responsible for the detention centre, who is designated as the superintendent, to take the information from the multidisciplinary review and make that decision.
What's the current philosophy which underpins how Banksia is managed?
So the current philosophy is to manage the young people in a safe, humane manner and to focus on providing appropriate supports to return them to the community.
Has that been the philosophy for some years?
The philosophy at Banksia has changed over, my understanding, over a number of years, with different models of care being put in, but never fully incorporated into the operations of the centre.
Well, how has it changed to what you say the current philosophy is?
So there's, as you know, we provided, there's a whole suite of work that's being done to develop an appropriate model of care that is therapeutic and supportive in nature. And whilst we're working through that, with the support of the site, we've implemented a much greater focus on a multidisciplinary review of detainees and how they're managed.
And is the current philosophy also under review?
Yes, that's part of the model of care that we're focusing on.
And this is the trauma-informed model of care?
That's correct.
Is that original work or is that model taken from elsewhere?
It's original work, but informed by youth custodial experts from across Australia.
And is the work being done to date reflected in any document?
Yes, it is, which I believe we provided the Commission.
When do you expect that to be finalised?
The model as such has been finalised, and obviously we need to work out the implementation plan.
Can I ask you, in relation to an unrelated topic, in the prisons or detention centre in Western Australia, do any of them have a hearing loop to assist people who are deaf or have impaired hearing?
I don't believe so.
Why not?
Look, it's probably a question I can't answer. It's not a question that's ever been put to me before, yeah, I need to seek further advice.
But you have, in your words, an accurate idea of prisoners with disability.
Yes.
That would include people that are either deaf or have hearing disability?
And so if somebody is identified with a hearing disability, obviously we provide, you know, the normal hearing aids and those sorts of supports that they would require.
Do you have a visual alarm in your prisons?
Visual alarm for what? Sorry?
For people that can't hear?
So there are no visual or audio alarms. If there's an emergency, staff ensure that prison detainees are able to, you know, move to a safe area.
Assuming they can find them.
That's what my staff do. My staff are there to manage the safety and welfare of prisoners and young people in our care, and ensure that they're, you know, managed. They're not just left to their own devices. There are always staff with prisoners and detainees.
Do all your prisons and Banksia have accessible cells for people that are wheelchair bound?
Yes.
Are there sufficient such accessible cells in all facilities?
All facilities have cells, and detainees obviously and prisoners are placed in those where there's a need. It may mean that they need to move into a different unit if there's not an accessible cell available in the one they're in.
Just going back to the question of deaf prisoners, if an announcement is made over a loudspeaker that there's some emergency, how does that person receive that information?
So the staff will then ensure that all prisoners are moved out of an area. So if we were evacuating the unit, they'd put a call on the tannoy saying, you know, everybody leave the unit. The staff then go and sweep the unit to check that everybody has heard, everybody has paid attention, and make sure all those people make it to the rally point.
You would have heard my questions of Mr. Reid and Dr. Cooney in relation to the representation of First Nations people on staff at Banksia.
Yes.
Why is there no First Nations person in senior management or executive levels at a place like that when 80% of the detainees are First Nations?
I think both their answer was reasonable, that we are increasing the number of Aboriginal staff. I did, after hearing their numbers, check. We're at about 7% Aboriginal staff for Banksia Hill, but we have about 21% of staff who haven't advised whether they're First Nations or not. But you know, working on the 7%, and I'm happy to commit to employing an Aboriginal staff member as a member of the senior management team for Banksia. It fits within the model, the operational model that we were developing. So I'm happy to make that commitment.
I thank you for that offer. When will we see that come to fruition?
It'll be by the first quarter of 23.
Chair, they're my questions.
Yes, thank you.
We'll just wait there for a moment, Mr. Reynolds, in case commissioners have any questions.
Yes, Commissioner Mason, do you have any further questions?
Thank you, Chair. Thank you very much for your evidence this afternoon. I just wanted to follow up just on that last question around an Aboriginal person working in senior management, because and this is about Banksia Hill, particularly because there are young people, young male and young women there, and large numbers of Aboriginal young people. The opportunity of providing governance, management, culturally safe approaches, connections to communities. I raised with the previous witnesses about having a senior man and senior woman because of that issue of women's culture as well as men's culture, and providing not just around management leadership but also around cultural leadership. You just mentioned around having one position there. Is there a possibility of that being a different approach with having a male and a female, just seeking your feedback and advice?
So certainly there's options for leadership positions to be, you know, both male and female. The the final makeup of what I would call the senior management structure, I would need to determine, you know, what we could achieve. I think it would be very good to have more than one First Nations person in a senior leadership role. Obviously, you know, I'll commit definitely to having one position that will classify 50D, which must be an Aboriginal person, and then identify what else, other improvements we can make.
Oh, such as the identified position, that's what you're talking about?
Yes.
Yeah. And just one other question, Mr. Griffin, is to the witness, in relation to the operating philosophy, have First Nations people with disability, whether they're inside the prison system or external, have they been provided an opportunity to input into that operating philosophy, or indeed generally people with disabilities? Thank you.
There's been a number of engagements with what I would call sort of youth custodial experts across Australia to provide us that advice. I'd have to really confirm exactly who with disability or from disability services had been formally consulted, but my understanding is it has.
Thank you very much.
Thank you. Commissioner McEwen?
No, thank you.
Thank you. Just one question from me. I noticed that Mr. Reid said his position reports to the Assistant Commissioner for Women and Young People. Where does that person fit in the chain of command, as it were?
Sure. So Mr. Reid reports to the Deputy Commissioner Women and Young People, and the Deputy Commissioner Women and Young People, Deputy Commissioner Jimby, reports to me, and she's part of my senior executive.
I see. All right, thank you very much. Thank you for your evidence today, and thank you for the information you've provided in writing to the Royal Commission. We appreciate your assistance. Thank you.
Thank you.
Chair, can we just have a short break and then we'll hear from Dr. Thomason?
Yes, just so we can all be aware of that timing, how long do you think that is likely to be?
The break or his evidence?
Let's take the evidence first and then we'll talk about the break.
I hope an hour.
An hour. All right, how long do you want? Just a few minutes?
Yes, 5 minutes will be fine.
We'll take an adjournment for 5 minutes. Thank you.
The Royal Commission is now adjourned. The Royal Commission is now in session.
Yes, Mr. Griffin.
I call Dr. Adam Thomason to give evidence. He has already made an affirmation, Chair.
Thank you. Dr. Thomason, thank you for coming to the Royal Commission to give evidence. Sorry to have kept you waiting for a little while. We do sometimes run behind schedule. Just so you know where everybody is, we have in Adelaide Commissioner Mason and Commissioner McEwen. I'm in the Sydney hearing room. Mr. Griffin, Senior Counsel assisting the Royal Commission, is also in the Sydney hearing room, and I shall ask him now to ask you some questions. Thank you.
Commissioners, Dr. Thomason is the Director General of the Western Australian Department of Justice. He's provided 2 statements for his public hearing. The first dated the 24th of August 2022, identifier WA.9999.0014.001. This statement is in hearing bundle C1, tab 2, and the attachments to the statement are at tabs 3 to 35. Your second statement is dated the 16th of September 2022, identifier STAT.0629.0001.001, appearing in hearing bundle C1 at tab 94, and the attachment AT1 is at tabs 95 to tab 103. Dr. Thomason, to the best of your ability, are those statements I've indicated true and correct?
Yes, they are.
You're an internationally recognised expert in the prevention of child abuse and family violence and the development of child protection and family support systems.
I think that's probably a fair statement.
Well, it's taken from the government website, so I'm assuming so.
Yeah.
You've been involved in the development of the National Child Protection Clearinghouse with the Australian Institute of Family Studies.
Correct.
You've been the Director General of Western Australian Department of Justice. Prior to that, you were the Director and Chief Executive of the Australian Institute of Criminology between 2009 and 2015.
Correct.
You've also worked in the Northern Territory. You're an honorary professor at the Australian Catholic University.
I was an honorary professor at the Australian Catholic University. That appointment lapsed.
And you were a member of the Criminal Justice Working Group of the Royal Commission into Institutional Responses to Child Sexual Abuse.
Yes, I was a member of that group.
And in terms of qualifications, you've got a Bachelor of Science with honours in psychology.
And a PhD.
And a PhD at Monash University.
What was your thesis in, if I may ask?
Basically, it was a real-world study of following 300 child protection matters around agencies, including police and child protection, to determine the reality of decision-making and case management decisions around those cases for 6 months.
Thank you.
Dr. Thomason, do you recall giving an interview with the Channel 7 program Flashpoint on Sunday, the 24th of April 2022, in that broadcast on that day?
Yeah, I gave the interview earlier, but yes, I do. That is the correct date.
If a transcript of that interview can be brought up, it's in Hearing Bundle D, tab 18. There's the identifier of DRC-9999-0163-0001. Do you have a copy of that transcript in front of you, or can you see it on a screen?
I can't see it on the screen. I don't have a copy with me. Hang on, it's coming up now. Thank you. I just need to, a little bit bigger would be helpful. If I could get that, that'd be great. Okay, thank you.
What were the circumstances that caused you to enter into this interview?
Well, as the Commission would be aware, I took a decision in early July that we needed to gazette a unit at Casuarina Adult Male Prison for the purpose of a youth detention facility. That caused, as you would expect, a lot of interest. We've got a lot of media requests, some of which we did, some we didn't. We obviously made a lot of comments, and essentially we were asked to do this, or I was asked to do this interview, and after seeking advice from my comms team and others, I chose to do it. I guess to some extent to get on the record from the department's perspective as to what had been happening and why I made the decisions I did.
Before I go to that interview, you've heard evidence, I presume, from the previous witnesses today?
Yes.
And you know I was exploring the decision to transfer the detainees from Banksia to Unit 18?
Yes.
Can I clarify who ultimately made that decision?
That decision was mine. I can take you through the process if you wish, but it was my decision when I then made contact with Minister for Corrective Services, the Honourable Bill Johnston MLA, and advised him that I thought we needed to gazette the unit and the reasons why. And then we went through a process, and subsequently on the 20th of July, I believe, 17 young people were transferred to Unit 18.
And were you the ultimate decision maker on the issue of the transfer of those 17?
Do you mean in terms of setting up the unit, or in terms of taking the points you made earlier around who actually determined which young people should be moved?
The latter.
The Banksia Hill Detention Centre made the determination as to which young people should be moved based on their behavioural issues and other concerns at the time, and it was based on an assessment by a multidisciplinary team, which I believe Commissioner Reynolds also referred to. So they made the decision. Obviously, I supported the decision in that I'd initiated the action in the first place.
Is it fair to say that you were consulted in relation to that decision?
I remember seeing summaries of the assessments done on the young people, a bit like Commissioner Reynolds indicated. I don't remember, I didn't retain a copy. I don't remember looking at them for a long period of time. I asked questions as to the criteria that were being used, and then at the end of the day, I endorsed the decision to transfer the young people.
What did you understand the criteria to be applied in determining who was to be transferred?
It predominantly came down to behaviour. As you would be aware from the evidence we've given today, and also in statements, for quite a period of time there had been a lot of disruption at Banksia Hill, and that took the form of fence climbs, unit roof ascents, assaults on staff, self-harm by the young people, and significant damage to cells to the extent that young people could actually then escape their cells. And what we were looking for is the individuals who had been significantly involved in those matters and who we felt needed to be managed in a more secure area for a period of time.
Just pausing there for a moment, Doctor. As you probably heard earlier in the day, the quality of my life partly depends on me being on good terms with the Auslan interpreters. They've indicated to me that they would appreciate if you could slow down in your response. I know you're experienced speaking publicly, but a useful guide is to take your normal speaking pace and halve it. It'll probably come out roughly a suitable pace. Can you do that for me?
I'll certainly give it a go.
Thank you. During the interview I referred to a moment ago, the interviewer was Tim McMillan, and he asked you about Hilton Quayle's comments as president of the Perth's Children's Court. And he referred to the comments including a description of Banksia as dehumanising, illegal and inadequate. And you're asked how you responded. And you'll see you responded, look, they're very strong comments by the judge and he's entitled to make those comments. When you said that, do you mean that you agreed with the comments or he simply had a right of free speech?
I actually think it was both those things. The judge, as you would know, is entitled to make whatever comments he deems fit. The courts are independent of government, they're part of a civil society. That said, I don't necessarily agree with all of his comments. I do think, we all know, Banksia was in a very difficult place at that particular point in time, a place that I didn't want it to be at. And so to some extent, I agree with him, but I think he was a little harsh in other ways.
In which ways, in your view, was he harsh in his comments?
Look, I can't remember all of them verbatim. He used, I think, the term monster, or we were creating monsters and some other things like that. And I thought that was perhaps a little uncalled for. That said, I did understand what he was trying to convey. I think what he was trying to convey was that the young people weren't being helped by the situation at Banksia, and we have an obligation, which I fully accept, that we need to look after young people as best we're able to and better prepare them for release and hopefully are desisting from criminal behaviour if they've been convicted of such.
And you indicated in your answer that you'd instituted a review to get a better understanding of what's been happening. Who conducted that review?
It was a review of what was happening with that young person, the particular young person that the judge was had before the court. And I can't remember precisely who I asked to do it. I believe a number of staff inside the Women and Young People's Division of Corrective Services were asked to look at it, but I honestly can't remember anymore. There's been a lot happening.
Did you contemplate that review being conducted by someone outside the department?
The first issue I was trying to resolve was how many hours the young person had spent in their cell and whether the figures that the judge had were accurate or fairly accurate. And for that, the department could do that. Banksia's got a lot of oversight by external bodies at any rate, and I wanted to just know, was it as bad as what was indicated, or was it not as much of a problem? And what was determined after a little bit of time, I forget how many weeks now, a couple of weeks I think, was that whilst we could quibble a little bit, essentially the judge was correct in that the young person was spending way too much time inside his cell.
How much time was this young person spending inside the cell according to those that advised you?
In some days, it wasn't every day, but in some days, I think in late January into early February, the young person was spending less than 1 hour out of cell on those days, on some days. I can't remember precisely, but we can find out and pass that to the Commission if need be.
Was this the first time you became aware of the particular situation of this young person?
Of that young person and the issue of hours, that was probably the judge's comments were the first time that I certainly queried it. That said, I was aware of a lot of lockdowns for a number of reasons inside Banksia Hill over the January-February period. At that time, the facility was what I subsequently described as a state of emergency, in the sense that there were multiple critical incidents, or code reds as they're called, happening each day. They took the form of assaults on staff, self-harm by some young people, roof climbs, damage to units, damage to cells. And what it meant was the facility was locking down continually almost to try and allow staff to be freed up to deal with those incidents and to manage the young people involved. And it wasn't one young person involved, it was multiple young people. That the person that we're talking about or the judge was seeing on that day in his court, that young person was involved in some of that too, from my recollection. So I knew who he was, in a sense that he was coming up in the incident reports that I get every day.
And so each day you're updated about what was happening at Banksia in respect to assaults on staff, damage to property, and other related issues.
We have critical incident reports for not just for Banksia Hill, but for the entire corrective service environment. They're produced by an operations centre centrally, and what they do is they are distributed to a wide range of staff and also to sometimes outside the department, and they summarise what we call a critical incident. So they're very serious incidents, and they may involve an escape from lawful custody, they may involve a death in custody, they may involve assaults on staff, assaults detainee to detainee or prisoner to prisoner. They may involve criminal damage, all the way up to riots. And those incident reports are updated as the incident changes, and I get those all the time, every day that I'm on duty, and also on the weekends, whenever I'm around, basically, as does the Commissioner. And it's an important way for me to keep track of the serious incidents that are happening in a particular facility.
Dr. Thomason, it's important to remember that the documentary evidence is before the Commission, and so I don't want to spend a lot of time in me repeating it or you reciting it. But in summary, you received on the very least a daily basis a report of exactly what was happening at Banksia.
I received, I said, the incident reports, they're specific incidents. I also received briefings from the Commissioner and others, if not on a daily basis, on probably every 2 days, but I would have spoken with Commissioner Reynolds on a daily basis at the worst of probably in January, February, March about Banksia.
And did those reports or briefings specify the effect on individual detainees of what was happening, particularly the fact that they were being kept in cells for long periods of time?
It would depend. Look, I could tell by the number of incidents I was receiving that the centre was locking down for a long period of time, and I actually raised that obviously with my senior staff, because it's not good practice. Even though I might understand why it was occurring, it still wasn't good, and it was one of the pressures building on the department and on myself to ensure we had Banksia working more optimally, and that means that we're able to unlock all the young people, that they get access to education, recreation, all the therapeutic supports, etc. And that wasn't happening certainly in the early part of this year, and for quite a considerable period into the middle of the year as well, until I made the decision about Unit 18. So I had those reports, but I also discussed, and we had discussions about out of cell hours at different points. That wouldn't have been daily, but I certainly raised it as an ongoing issue with my reporting from corrective services to me.
And had you been told in a briefing that there were detainees that were spending 23 hours in a day in a cell, I presume you would have done something about that immediately.
There are relatively limited things that can be done about that circumstance when the centre was having so many incidents. That said, what I was more surprised by was, and it comes from Judge Quayle's comments, and that particular individual, was lockdowns and as a result of staff shortage, rather than lockdowns as a result of needing to ensure the facility was safe and secure. And I have powers, I guess, under both. And you've referred to earlier today the Supreme Court ruling about unlawful confinement based around staff shortages. That may be one element of what happens at Banksia, which we've stopped. But at the same time, we will still have lockdowns if young people are harming themselves, destroying facilities, rioting, or assaulting staff at different points. There will be lockdowns.
I understand that, Dr. Thomason, but I'm really coming from the perspective of the detainee. May well be that the reasons you advanced created the situation, but to what extent did you turn your mind to the effect this was having on individual detainees that were being locked away for 23 hours a day?
There's a number of areas with that. The first one is you need to understand why the lockdowns were happening. And whilst a young person at Banksia may have complex needs, many of them do, as is in the evidence, the reality is it's the behaviour of a cohort of young people was meaning the centre couldn't function adequately. Now, as part of my consideration of what was happening at Banksia, I certainly also considered what could we do to reduce the lockdowns and get the facility more stable and have the young people, if you like, acting in a way that allowed us to have the facility working the way it was designed, which was access to services, not in cells but outside of cells, all that sort of thing. So I would have had individual discussions about individuals at certain points. My initial response was ensuring the self-harm incidents were responded to adequately and trying to cease those, but also trying to maintain a safe and stable centre. So sometimes individual considerations come into that, but I've also got a broader consideration of the individual staff and the individual detainees not involved in specific incidents as well. And I try to consider all of that.
As a matter of interest, how old was the boy about whom the president of the Children's Court was speaking?
I think he was 14, Commissioner, but I honestly can't remember anymore.
He was 14 years old and in a cell up to 23 hours a day for a period of 11 weeks.
I don't think it was 11 weeks. It was certainly a number of days in a period of time in January, February. But yes, he was locked down more than he should have been, that we would have liked him to have been, but there were reasons for that.
Well, I think you were asked about the 11 weeks in the interview, and I don't think you rejected the proposition that it had occurred over 11 weeks.
Banksia Hill, and I'm aware of testimony given by other members of the department today. To my mind, from September last year, September 2021, we started seeing a significant increase in incidents of varying sorts. The nature of those incidents actually changed over the course of the last year. But that said, there were a complex needs group of young people, a cohort, if you like, who made it very difficult for us to manage the centre the way we would like. So lockdowns for various reasons, but particularly because of critical incidents, were occurring at a much higher rate than I would have liked. I would say certainly from late September all the way up to the move of some young people to Unit 18 in late July at varying points. Now, the behaviour that was leading to the incidents changed. It was different points, and sometimes it was limited lockdown, sometimes it was a longer period, depending on what was happening and how many incidents were occurring. But it was a sustained period, which as I said, I described it as a state of emergency. It was very difficult to manage. And whilst the staff, I think, did a great job at trying to be humane and trying to reduce lockdowns, the reality was Banksia could not run the way it was meant to during that period.
Dr. Thomason, to pick up on the Chair's question, it's my understanding that the young person to whom Judge Quayle was referring was diagnosed with FASD. You understand that?
I'm not surprised at all. I would expect that. Yep.
PTSD. Were you aware of that? And developmental disabilities.
It's not surprising.
And irrespective of how long it was, but let's assume 11 weeks because you don't specifically reject that in the interview, that cannot be the best option, surely, for someone in that position.
Well, what I say in an interview isn't obviously sworn testimony. That said, I do agree there was a period of, I would say, more than 11 weeks where we were locking down.
Doctor, I want you to address my question.
I'm going to, Counsel.
I want you to stop making long responses. Do you accept that if that young person suffered from FASD, PSD and developmental disabilities, it was not the best option for him to put him in a cell for 23 hours a day for a long period of time? Do you accept that proposition?
I accept it.
Do you also accept it's fair to describe it as cruel and unusual punishment?
No, I don't. I don't think it was a cruel and unusual punishment. We didn't do it to punish the young person. We did it because that was the only option we had.
Was it the effect of it to be cruel and unusual punishment?
I wouldn't use that terminology. I don't think it was anywhere near ideal for that young person or any young person.
that it wasn't cruel and unusual punishment for a 14-year-old boy to be locked up 23 hours a day, up to 23 hours a day, regularly over a period of 11 weeks. You don't describe that as cruel and unusual punishment.
No, I describe it as what I had to deal with at the time.
Would
Very
you
good.
characterise it as child abuse,
No, I would not.
even given your extensive history of working in that area?
Look, I'm absolutely prepared to accept that it wasn't acceptable and it was not great practice to treat that young man the way he was, in the sense that he was locked up for way too long. Absolutely, I accept that. But I had no other option for that young person until we re-rolled the Unit 18. And even then, that young person, if he's in custody, and I don't think he is at Banksia or at Unit 18 at the moment, but I don't know for sure, that was what I've got is what I've got to deal with. I would prefer that a young person like that would be housed elsewhere in a different sort of facility. I don't have that option.
Well, when you became aware of what had happened to that young person and the comments of Judge Quayle, what did you do?
Firstly, I rang Commissioner Reynolds and we discussed that with some of his team around, as I said, I wanted a review done. Are these figures correct? Because they're not acceptable. We did the review and we found the numbers were pretty much close enough that the judge is, he was in the ballpark, if I can put it that way. So that was the first thing we worked out. And then we looked at, from my recollection, we looked at what we could do to try and improve things, not just for that young person, but how Banksia was running.
Yes, but what did you specifically do for this young person when you became aware of that information?
Apart from what I've just described, I can't recall what else I did specifically.
Did you contact the minister and say, look, this is unacceptable. We need an intervention at ministerial level. We need whatever resources are required to stop this immediately.
I certainly briefed the minister and his team on this particular matter, as I do with all the significant matters at Banksia and other parts of the environment that I operate.
And what did the minister say when you briefed him about this young person?
Apart from not being happy with the situation and needing to be resolved in some sense, I can't recall precisely what he said.
Why was it not an option to place this young person in that unit, the acronym for which I've forgotten?
EMU.
EMU.
For that individual, I can't say whether we referred him to EMU or not. What I can say is we referred a number of young men.
No, please do attend my question.
Well, I'm trying to.
Well, you're not, in fact. What was preventing this young person, 14-year-old, with all the conditions that have been described, being placed in EMU in order to give him the support for some fairly obvious acute psychosocial condition?
One, the decision is not mine. It's a psychiatrist who runs that facility. Second, there's a threshold in terms of getting into that facility, and there are 10 beds in total. It's very rare to get a young person from Banksia Hill into that facility. Third element would be, is it a mental health concern, a behavioural concern, or a cognitive impairment? Unless it's a mental health concern, often we get told the young person is not suitable for that environment and therefore they stay with us.
Did you hear Dr. Cooney's evidence today where, as I recall, she said that if a detainee with acute mental health needs was so assessed, they could be placed in EMU, no problem?
Yes, and I take issue with that evidence because from what I'm advised from looking at this over the last year in particular, very few of the Banksia young people have actually managed to get into EMU. So either they didn't apply for this person, and I can't tell you right now whether they did apply or not. What I can say is very few from Banksia end up in that unit, and if they do go, it's for a very limited period of time.
Yes, thank you.
If this wasn't cruel and unusual, does that mean that this sort of thing was happening regularly?
As I've indicated, there are a lot of reasons why young people were locked down in cells.
Was it happening regularly?
Yes, it was. There was regular lockdowns of young people in January, February this year.
Given the fact that we understand that one of the precursors to this was staff shortage, you heard the evidence from the previous witness. What can be done to bring in staff on an urgent basis rather than wait for a long recruitment process?
Commissioner Reynolds made the point, I think, that we had actually asked volunteers, prison officers, to supplement the Banksia Hill team to allow youth corrections, youth custodial officers to actually focus on the young people. That's one thing we did. Allied health staff, again, we could, and we did seek opportunities to bring in NGOs as well as allied health into the facility. In terms of uniformed officers, unless there's some form of training involved, it can be quite difficult just to sort of bring someone in. That said, I don't think Commissioner Reynolds made the point that we are also looking at a bridging course in case a prison officer or equivalent, or a youth justice officer, which is a community corrections worker who works with young people on the outside, wanted to make a transition to be a YCO, so a bridging course that would be a shorter period rather than 12 weeks. We've been looking at that too, and vice versa around YCOs who may wish to become prison officers, assisting them with that transition. So we're doing that, and you have also heard that a temporary allowance was put in to match salaries to encourage young youth custodial officers to stay in the system as well.
You told the interviewer at Channel 7 you had an obligation to make sure the facility is run safely, staff are safe, and the young people are safe. Is your understanding of keeping a young person safe locking them in a cell for 23 hours a day?
Well, they're safe in the sense that they're not actually walking through broken glass. They're safe in the sense that they're not actually able to get into trouble by, for example, climbing fences and falling off them. Is it ideal? No, it's not. And I think I've conveyed that I don't think it's ideal.
Well, you have conveyed that, but it seems from your answer that that is, in your definition, keeping them safe.
Can I explain just what was going on at Banksia? I'll try not to be too long, but if staff are being assaulted, if young people are self-harming in a usual unit at Banksia Hill, if they're jumping on fences and breaking things on roofs and potentially falling off, these aren't safe behaviours for staff or for the young people themselves. If the existing units aren't able to assist us to monitor the young person's behaviour so they don't hurt themselves, and they're not safe because they can be dismantled because the young people, a particular cohort, has taught themselves and shared that information as to how to pull apart a cell which has been used for 25 years reasonably successfully in the sense that it wasn't breached. These things mean that you have to do something else. You have to put a young person somewhere safe in the facility you've got. That's my answer to that. I can't give you anything else. That was part of trying to keep these young people and the rest of the facility safe, was putting them somewhere where they couldn't break out of, and then work on a solution that would be better than what that option was.
You also told the interviewer that about 60 to 67 staff members a day would be about right. And yet, at the time, there was only between 30 and 40.
That's correct. 60 to 67 is around, I think, a full shift for uniformed officers at Banksia, and there were less than that.
Staff shortages at Banksia had been a problem for a long period of time, had it not?
From my recollection, there was, and I know you've asked a question earlier about attrition rates, there was a reduction in available staff from around, I'm going to say September last year, which to me coincided with an increase in incidents. Not surprisingly, when a flurry of incidents occur, some staff will have workers' compensation claims, some will take leave, and there was a reduction in staff from that period. And that continued over the period of more intense sort of incident numbers into sort of early 2022. We also at that point, as I think was referred to earlier, had run 3 classes, and we had about, don't quote me, I think it was around 40 to 50, maybe 60 staff come on board, new staff, by about February, March this year. But we also had additional attrition going forward. So, and we're running more courses to try and keep up.
But there had been a staff shortage problem for some time at Banksia.
There's certainly been some staff shortages. I don't remember it being a critical issue prior to when we started seeing the increase in incidents. I'm sure there was certainly not a full complement of staff at different points over over previous years. Absolutely.
Based upon your inquiries, when was the last time Banksia had, to use your expression, a full complement of staff?
I don't know.
Well, isn't that something important to know?
I don't actually think it is. I'm more interested in going forward, having the complement of staff. The more staff I can get, the better. I do actually want a full complement. But there have been some days, I think in January, February, we actually had around the 60 staff. But generally speaking, we were way below that. I don't like it, but that's the reality, what we were experiencing.
Well, you heard the questions and answers from the previous witness about exit interviews.
Mm-hmm.
Do you accept that in recent times there's been a high attrition rate of staff at Banksia, do you not?
I do.
That's risen to approximately 25% annually.
I don't know if that's correct, but I'm happy to accept it. I haven't actually checked myself, but I'm happy to accept it.
Let's assume that's correct. That's an unacceptably high attrition rate for any organisation, isn't it?
Agreed.
Would you agree that such an attrition rate will tend to degrade the culture and level of experience of the staff working?
I think that's a fair point.
Why has not more effort been made to ascertain why staff have been leaving?
Well, Commissioner Reynolds talked about exit interviews and the small proportion of staff who choose to fill them in. He's talked about the managers asking why someone may go, but at the same time, we've also got information through the site, and it would be through the management, not through individuals. And I've also seen things like workers' compensation claims and other things from staff who have subsequently left Banksia, which indicates a degree of trauma from the experiences they've had working at Banksia. And that's trauma in various ways.
So as of today, what do you understand to be the primary reasons why staff have left the unit?
Firstly, the psychological trauma they experienced in managing the critical incidents and that significant increase over the last year or so. Secondly, the physical and other assaults they've experienced as staff by detainees. Thirdly, I think the pressure to some extent of trying to manage that facility with less staff than we would like, but also in terms of the complex needs of the young people who are present. And I think also, and this is my personal view, most of our staff rightfully have the view they want to operate a therapeutic service, and they recognise that we couldn't do that in the environment we've been working in up until I started to gazette Unit 18 to try and resettle Banksia.
Do you say that before the troubles at Banksia, a suitable therapeutic environment existed?
I don't think it was perfect by any means, and the Inspector of Custodial Services reports would say that, but I do think it was generally okay. It wasn't perfect, but it was okay.
Well, Dr. Thomason, could I ask you, remind you again, please just slow down a little, thank you. It will help our interpreters.
Sorry.
Have you been back through the various reports of the inspectors of custodial services?
At different points I have, not all of them today, but I've been through obviously the show cause notice at Christmas 2021. I've been through the report that came in just before the difficulties and the issues we faced in late 2021. And I'm aware of, from previous reading, of some of the earlier reports from Professor Morgan.
And from your reading of those reports, have there been recurrent issues raised by the previous inspector and the current inspector?
Yes.
And do you accept that some of those issues have not been adequately addressed?
Yes.
Why? Firstly, indicate the issue and tell the commissioners why that issue has not been adequately addressed.
Well, the model of care is one of the key areas where the previous inspector and the current inspector have both pointed out they didn't think it was fit for purpose. They didn't think, I think Professor Morgan had indicated he didn't feel we had engaged staff enough in the process, and I think he was right with that. A number of attempts were made to improve the model of care, which I don't think have gone particularly well, which is why we've had to reinitiate a model this year to try and get it right finally, and I hope we have done that, but it's early days.
Why do you think previous attempts to modify the model of care have been unsuccessful?
I don't think they engaged adequately with the staff at Banksia for one, and also one could argue with some of the young people who either been in Banksia or who had left Banksia and trying to get the sort of the user's experience, if I can put it that way. I think that's an important element. But I think the staff, because that staff told me this, and I have gone out to Banksia a few times, that they felt they didn't own the model, and that was hindering their ability to, I guess, enact what we wanted. There were also concerns around whether the model, one of which was the Missouri model, which is an American model, was actually fit for purpose for the nature of the site itself.
And the task force that Mr. Reynolds referred to, that is looking at the model and the philosophy of Banksia?
I might have missed the task force reference, but there has been a group within the department and also a consultant brought in to work on that model of care and the philosophy behind it. The implementation will be the key thing.
Who's the consultant you've brought in?
Nous Consulting.
Right. And is that a particular person within that group?
Tim Marnie was the person, the ex-Mental Health Commissioner of Western Australia. He led the team. I can't recall the names of the others involved.
And where is that work currently up to?
It's close to being finished. There is a draft report. There's some further stakeholder consultation going on. And what I'm looking to do then is see how the implementation of that model will be enacted.
Can you indicate to the commissioners what the principal characteristics of the draft new model are?
Well, there are a number of, I guess, tenets, and I don't think in many ways they're things that are very different from previous models, but it's how they'll be enacted, I think, will be the key thing. So things like obviously trying to provide a therapeutic environment, trauma-informed work, and I know that's been discussed earlier today, but the intention of recognising the traumatic experiences that young people will have experienced and how that will affect their behaviour and how we should assist them when they're in custody with the Department of Justice. I'd have to refer to my notes for the other key tenets, but they're not unusual ones in terms of these models. The implementation will be key.
Does the new model also include an examination about whether existing management should remain in their positions?
No, not formally. We will look at how the management structure, I guess, facilitates the model of care. That would be the main thing.
What about the suitability of individuals to continue in senior roles?
That's not something we're contemplating at the moment.
Why not?
Because I think we already made one change in superintendent, as Superintendent Reid said, I think November last year, and that was to put in, one, to give a change to an individual who'd been there for some time, and secondly, because he wanted Superintendent and his skills, Superintendent Reid and his skills to be brought into the picture. So I think it's fair to say we look at the structure at Banksia and other facilities to try and get the best out of it on a regular basis, but it's not going to be a formal review.
I want to raise a proposition for your consideration and comment. Is it possible that senior staff that have worked for many years in the custodial setting are wedded to a model which has the good order of the facility as the paramount consideration, and might find it difficult to shift with the times?
That's a fair point. I've seen that in other areas of corrections in the years I've been in this role. There are also, on the flip side, a lot of staff who are quite innovative and want, if you like, the best for the young people in their care and actually want to innovate. So, look, you're right. There is a consideration around staff of all levels and making sure that they understand the message and they embrace it and they will deliver the service required. I think that's a fair point.
They have to believe it, don't they?
And that's one of the reasons why we wanted the staff more actively involved in developing the model, because in the past, one of the comments was, as I said earlier, we weren't consulted, we don't own it. And that's my paraphrasing.
I want to put another proposition for your consideration. But when one looks globally at the history of Banksia, there's been no effective solution to understaffing. This has had an effect on education programs, therapeutic support, and a range of other things for detainees. There's no effective access to acute mental health treatment. There's no effective screening mechanism.
Well, I think there are a number of propositions. Do you want to break them
No,
up?
I just want, the proposition I want to put to you is, isn't the system broken? Doesn't it need a root and branch review rather than tinkering at the edges in relation to Banksia?
I'm just considering what you said. I think the situation we've found ourselves in does lead itself to doing something different if we can. I don't think over the course of the 25 years of Banksia Hill, and I've only been here for 6 roughly, but I'm aware of some of the histories going back to 2010. I don't think it's always been broken. I don't think all of the problems you identify were always massive problems. I do think they've come across at particular risk periods where they have been more salient, I guess, as issues to consider. So it comes and goes. Banksia can be stable for a few years, and I think the Inspector Custodial Services says this, and then we have a major issue, a riot, or what we've found ourselves in. Look, I think if we can do things better, I would certainly want to.
Because in relation to the detainees that were transferred to Unit 18, and we haven't seen the assessments that led to that decision, a number of those 17 were then released or presumably moved into the adult prison population, but in any event didn't return to Banksia, correct?
You're correct. Into the adult prison population, I don't think's occurred. It's been more released to freedom. Some have gone back to Banksia and then released to freedom after a period of in detention there, either remand or sentenced. But yeah, it's been a change. There are currently 10, of which I think 2 have been there since we gazetted the youth detention facility and moved the people on the 20th of July.
So since the initial transfer, 8 new people have been transferred.
Yes.
Now, they weren't part of the so-called cohort you referred to that were causing all the problems. They were subsequent, weren't they?
They were certainly subsequent, but they were certainly part of a cohort, though, on the outside of young people who may come into Banksia on a fairly frequent basis, who we had experience of during the period from September last year through till July this year, who may have come back in. They all went to Banksia, and then based on behaviour, they were assessed whether they needed to be sent to Unit 18 for a period of time. It would be more than, we've got 10 there today, that we've had different numbers at the Unit 18 facility day to day. It varies and it changes quite quickly.
Dr. Thomason, don't we get into a situation of chicken and egg? Somebody has severe disabilities. They get placed in isolation or some form of restriction. Their conduct may then reflect the disability. That in turn is interpreted as affecting the peace and good order of the management of the centre. That leads to alerts, which leads to their transfer. My question is, if that characterisation is a reasonable one, in your opinion, how do we break the nexus?
Can I say there are a lot of young people in Banksia who haven't gone to Unit 18 who have similar levels of complex needs. Only some have engaged over the last year or so have engaged in behaviour that's been very, very difficult to manage on a consistent and regular basis. So I think that's the first thing, is not every young person, just because they have complex needs, will be considered to go to Unit 18. Not every young person at Banksia Hill has engaged in the level of ongoing behaviour that you're talking about. So I understand your chicken and egg comment, but it doesn't apply to lots of other young people. It applies to a particular cohort, and that will change over time as young people are released to freedom and then may potentially come back into Banksia.
But if one labels them as part of a cohort, it then becomes quite inevitable what their fate is, doesn't it?
Well, it depends on whether you're actually saying, okay, well, this young person here is part of this cohort. Cohort's also a shorthand that I'm using, and which I've used before, to identify a group of young people, the members of which may change, who are very difficult to manage and have been very difficult to manage, and who usually have complex needs. I'm not labeling the individuals who may come into Banksia as a starting point. Now, obviously, you've heard there are assessments done at Banksia for each young person who comes in, but it's behavioural as to whether they end up being considered for Unit 18. I don't think it's a preordained label, or if you like, action.
But your defence of the decision to transfer to Unit 18 was very much based on a characterisation of these individuals being part of a cohort, which not only related to their conduct in Banksia, but your understanding of the conduct in the community before they came to Banksia.
That's correct.
With the 8 that Mr. Griffin referred to that have gone to Banksia after the time we were talking about, and I think there may have been more than 8 because there were some have come in and some have gone. Were those 8 all responsible for serious acts of disruption, or was there some element of preventative measures being taken about the possibility of them engaging in such conduct?
Whilst we're aware of if a young person comes into Banksia Hill, and we've had that young person before on a number of occasions, and they've been involved in serious incidents, we would know that clearly. That isn't necessarily why they'll end up at Unit 18. It's not. That's not the primary reason. It comes down to current behaviour and can we manage them effectively without disrupting their educational and other therapeutic experience.
Are you able to say that all of those who were transferred to Banksia after the initial cohort of 17, that all of them were transferred because of their behaviour after their latest term of incarceration?
I can't say that because I haven't got that detail in front of me.
Is it possible that some of them were transferred because of their conduct prior to their latest incarceration?
It depends if you include conduct in the community prior to entering Banksia.
Yes, I'm including that.
Oh, in that case, if a young person has been involved in an incident which has led them to come into Banksia and it's quite significant, that young person, and I'm talking about quite dangerous, that young person may potentially have gone to Unit 18 on that basis. The majority of the young people who are sent there, it's because of issues inside Banksia, as in...
I understand, but there are some who were sent to Banksia because of concern about what they might do in Banksia rather than what they've actually done in Banksia.
I can't swear that's not the case, so I'm going to say it's a possibility.
And in addition to that, Dr. Thomason, a number of those people in Banksia are on remand. So what they've done in the community is only an allegation. It hasn't been the subject of a determination.
That's true, but there's some behaviour which may involve the department staff themselves where it may or may not lead to a criminal conviction, but their behaviour was quite dangerous regardless.
But nonetheless, you can understand, can you not? There's a difference basing a decision upon a determination of an independent body, a court, as opposed to relying upon information from police or others as to an allegation of what somebody may have done.
I don't really, well, I'm not going to get into obviously individual matters, but there's one I'm thinking of which was quite a significant incident, and that young person has not had his day in court in terms of being determined whether he's guilty or not guilty or equivalent. That said, I'm assuming, and I could be wrong, I'm assuming the behaviour as he was being taken into custody would have played some part of the assessment of that young person and where he was then housed. Now, he started off at Banksia Hill. I'm aware he was transferred to Unit 18. I don't know the detail without checking as to what factors were taken into account, but I would expect that some of the behaviour leading up to his, as part of his journey into custody, that would have been part of it. But I'm not saying he didn't do things inside Banksia that were also concerning, but I honestly can't tell you definitively.
Yes. But nonetheless, the conduct of the person prior to coming to Banksia was a relevant consideration in your decision.
Look, it wasn't my decision, but I'm certainly happy to back the department and Banksia Hill on making it. And I'm aware of, I said, that young person's situation. And I think it was quite a serious incident. And if that was taken into account, I would think it was a reasonable thing.
Can I take you to paragraph 27 of what I'll describe as your second statement, which is the one of the 16th of September 2022.
Mhm.
You refer there to the Inspector of Custodial Services commencing an inspection of ISU at Banksia.
Correct? Yep,
He issued a show cause notice
we did.
under his act, and he expressed the view that he formed a reasonable suspicion that there was a serious risk to the care or welfare of detainees held in the ISU at Banksia, and secondly, that the detainees were being subjected to cruel, inhuman or degrading treatment in the ISU at Banksia.
That was his consideration, his comments, yes.
That was a suspicion he formed. Did you accept that suspicion that he outlined in his report, in the show cause notice?
I think I certainly accepted there's a serious risk to the care or welfare of detainees because I'd been briefing the inspector for some months prior to that around what we were trying to do to reduce tensions at Banksia.
I'm particularly interested in your comment in relation to point B.
Oh, I was getting to that. I can't say I spent a lot of time on his language. My concern was, is there a serious risk to the care and welfare? And that was really how I framed it. And I guess we're back to definitions on how I feel about the treatment given out at Banksia. Do I think it's the best possible? Absolutely not. Would I have called it cruel, inhuman, or degrading? I wouldn't have, but I would certainly accept it wasn't acceptable and we needed to do something about it.
You understand he's picking up language which appears in international covenants, isn't he?
Yes.
And you'd be familiar with those from your previous work.
Yes, I haven't read them for a while, but I'm familiar with them for sure.
So those terms, cruel, inhuman, degrading, are not novel terms to be used, are they?
No.
And they're used in some international instruments as a benchmark to try and measure treatment against. You're nodding, you agree?
Yep.
Do you accept that detainees in Banksia were being subjected to cruel, inhuman or degrading treatment in the ISU?
It's not language I would use, but I'll accept it.
And you would accept that's a very, very serious conclusion to reach, isn't it?
Yes.
A conclusion that requires an immediate response from the perspective of the detainee to relieve them from that situation.
Yes.
You understand, I take it, that that language is also, apart from other international agreements in the Convention on the Rights of Persons with Disabilities.
Sure. I accept that. And it's not like we were sitting on our hands trying not to do anything. I'll just say that.
Don't think my question implied that, but carry on, Mr. Griffin.
Dr. Thomason, we've also heard evidence that approximately 70% of the population of detainees in Banksia at any one time are on remand.
Correct.
You would accept that that means that they haven't been convicted of
Correct.
Whatever the allegation is against them.
Certainly.
Do you have a different view in relation to detainees on remand as opposed to detainees who've been sentenced?
In what sense?
Well, Mr. Shepherd was drawing a distinction.
Wasn't Mr. Shepherd?
Sorry, Mr. Reynolds was drawing a distinction between the behaviour in his experience of prisoners as opposed to remandees. Let me ask you that question. Are you able to comment about whether you believe there is an empirical distinction between the behaviour of sentenced prisoners and people on remand?
I do think Commissioner Reynolds, and I'll get to empirical in a minute, but I do think Commissioner Reynolds is correct in that young people on remand, or adults on remand for that matter, there is more instability in their circumstances, and that can lead to the person involved feeling not sure what's going to happen next and what their future is, and giving them, if you like, an understanding of where they're up to. In terms of empirical evidence of it, I haven't got that in front of me. We could certainly seek some. I think you'll find there is a distinction between what is provided, certainly in the adult system, to remandees versus sentenced prisoners. And it does affect their classification and other things. In terms of young people, a young person on remand at Banksia Hill on average spends about 13 days at the facility. Now, it's longer than that. That's the average. Some will be longer, some will be much shorter, because they are there because of things like appropriate accommodation wasn't available, or something else is happening in their circumstance which precludes bail for a period of time. But often they're out very quickly. Sentenced young people, as you said, are now about 30% of the population at Banksia in particular. That's changed a lot in the last 10, 15 years. And they're there for, I think, an average of 130 days. So again, you'll see a stability of the young person, I would expect. It's not empirical, but I would expect, in the sense that they know they're there for a particular period of time. They have an end date. But we have the majority of young people, as you've said, are remandees who are there for short periods, but they may come back for a number of short periods over the course of years.
And those remandees may be less familiar with how the centre operates on a daily basis than sentenced detainees.
Well, again, half of the young people who come to Banksia don't come back, which is good. That's too many who do come forward. I would have thought once you've done a period of time at Banksia, the first time as on remand or sentenced, you would have an idea of the regime. That would obviously help a young person acclimatise better on subsequent visits.
When you say half don't come back to Banksia, does that take account of those who may leave Banksia but then find themselves later on in the adult prison system?
The period of time that is used for that KPI, that key performance indicator, is 2 years. So a 2-year return to Banksia. You're correct, Chair, that young people may come back if they're coming in at a relative, let's say at the age of 14. They may come back at the age of 17, and that, in which case that figure wouldn't be wouldn't hold.
No, I'm thinking, for example, of a 16-year-old who's in Banksia and then leaves Banksia for one reason or another, but then 3 years later is back in the system because he or she is imprisoned in Casuarina or wherever.
I haven't got those figures, but there is empirical research in Australia around that. The New South Wales Bureau of Crime Statistics and Research did a piece, as did a cohort study in Queensland at Griffith University. Both indicated if a young person spends time at a youth detention facility, and I think they used Queensland and New South Wales data rather than West Australian data, but it would probably still hold, I would suspect. There was quite a strong indication of significant probability a young person would spend time in an adult facility at some point.
Dr. Thomason, I also want to ask you about the Supreme Court decision of VYZ. I take it you've read that decision?
Yes.
As I've asked previous witnesses, what was your take on the decision of Justice Tottle in terms of your position and how you reacted to it?
My reaction, I guess, was twofold. One was, if we go by the full, I guess, the meaning of the Act or the terms of the Act, it will be very hard for us to manage Banksia when it's not a settled facility. Second element was around the nature of the use of long confinement or limited out-of-cell hours. And by that, I mean the concern was around staff shortages leading to the lockdowns, and that was unlawful, and I accept that, and obviously we'll work very hard to avoid that. But it didn't preclude me, and I have obligations under various legislation, including work health and safety, that if the safety and the security of the facility requires lockdowns, that I can still use those. Now, that doesn't mean I can be deliberately abusive or use terms that you may wish me to use, or that I can just lock kids down because I feel like it. But if we have multiple incidents occurring over the course of the day, then young people are going to spend time in cells more than I would like and less than we would expect for the system. That's what I took out of it.
Similarly, you would have heard my questions concerning the Sentencing Act and access to pre-sentence reports. Did you only become aware of the effect of Section 24A today?
I was not aware of an issue for our staff accessing those reports until I heard the testimony of Dr. Rowland today. It had not been raised with me, and I was unhappy to hear that. That said, I also heard what you said, Council, around the other part of the Act, and I sought advice from my policy team around what was current practice. And so at the moment, those reports are available to our staff, but there are still issues around the provision of information to some of our consultant staff who may not be employed by us and how they can access it. There have also been matters raised, if I can just refer to my notes, in terms of a coronial recommendation made into the death of a person in 2019 about the release of court-ordered medical reports to medical and nursing staff treating remand or sentenced prisoners. And we are looking at what the impact of that would be and how we might do an amendment to the Sentencing Act. There have also been considerations around the flow of information between youth justice and adult custodial services in the context of young people who, as the chair said, may move into the adult system. So I wasn't aware of the specific issue that was raised, and I was not aware of the fact we were relying on 2014 advice from state solicitors, as it's now called. But I was at least happy to hear that, in fact, that impediment for our staff accessing those records was found not to be correct, and at least they're getting into it and getting those records.
Do you receive legal advice from the state solicitor, but also from the legislative group in your department?
Predominantly state solicitors is the port of call because they're the lawyers for government. The legislative review section of my department, whilst it has lawyers in there, they're more the policy side, so I will use them as the vehicle to get me the advice, if I can put it that way.
Your background would indicate that access to those pre-sentence reports, particularly from specialists, would have been invaluable in dealing with certain detainees.
Agreed.
Can you explain why Dr. Rowland and others appeared to be under a misapprehension as to what the powers of access were?
I can't really, apart from saying, and Dr. Rowland now is obviously, she heads our health area. Day to day, she's not as active in casework as what she would have been because that's not her role anymore. I'm hopeful that the sites where we're actually dealing with people in our custody, that they were accessing the reports, but I can't guarantee it without obviously seeking further advice. So it may be on that basis that Dr. Rowland, it hadn't been, if you like, a salient issue for her as much, but I honestly don't know. It surprised me. I was not aware.
Can I take you to paragraph 51 of your second statement? If you could just read it to yourself briefly.
Okay.
You'll see there that you say, particularly in relation to recidivist young offenders, they often present with behavioural, psychological and psychiatric conditions and cognitive impairments. Hence the importance of treating young persons like those holistically.
Mm-hmm. Yes.
Too often previous attempts made to engage the young person and their families have failed or been ineffective, and they end up as high needs young people for relatively brief periods at Banksia.
Yes.
Where the unrealistic expectation is that their complex issues will be remedied.
Yes.
Who holds the expectation that complex disability issues will be remedied by Banksia?
It's my view there's a general perception that a young person's in care without understanding how the systems work, that we will fix, inverted commas, some of the issues young people have that they're presenting with, some of which may not be fixable. That may be underlying developmental problems, maybe mental health concerns that require significant and ongoing treatment. And again, I draw your attention to my previous comment, particularly for remandees, the time spent in Banksia is quite short. We have an opportunity there to try to stabilise young people. We have an opportunity to try and get the through care, as it's called, right, whereby they're referred to services outside and linked up with services, hopefully some they're already using. But we can't, I don't think it's realistic to expect that the problems a young person comes in with, that we can sort a lot of those out in the time that we have. With sentenced young people, I think we have a greater opportunity and a greater obligation. And I want to fix as much as I can. I want to remedy as much as I can, as do my staff, but that can be difficult. But I think we've got when a young person is with us for a longer period, I think we can help stabilise that young person a bit better.
Is it your expectation that such people will be cared for and managed rather than remedied?
Say that again, sorry.
Is it your expectation that Banksia will care for and manage those young people rather than remedy them?
Look, I'd like some rehabilitation, as some of the previous witnesses have said. That's obviously one of our goals, is to have young people desist from offending and get onto a positive life course. I'm also a realist. I've worked child protection. I've now worked youth justice. The young people we often meet have complex needs. It's going to take a long effort to try and make some change. That doesn't mean you don't try. It just means it's hard.
Now, I understand that, especially those there for a small, short period of time, there might be a limit to what you can do. But picking up on the questions to Dr. Rowland, is there more that could be done in linking those people upon release to the NDIS or to other service providers which might be able to follow up on the things that you may have identified during their period at Banksia?
The short answer is yes, I think we can improve. The slightly longer answer is I think we are continuing to improve our through care processes, but there's still a fair way to go. I agree.
This Commission has heard evidence both in this hearing and also in a hearing in Alice Springs about the possibility of using Aboriginal community organisations to come into facilities to assist the full-time staff in the sorts of ways I referred to this morning: cultural safety, cultural sensitivity, linking, what they'll be like back in the community. What can your department, via the management of Banksia, do to assist that process, if anything?
Well, we do have NGOs that come into Banksia already, Aboriginal NGOs of varying sorts. Some run recreational programs and mentoring sort of programs. Others are more therapeutic in nature. We do have those. Could we improve it? Well, I'm going to say yes, we could. There's always room for improvement. And I do take the point that was made earlier around having some senior Aboriginal staff in the staff cohort as a way of demonstrating some better cultural security, and to make the young people, essentially give them faces that they're more familiar with, if I can put it that way. So I agree with that. But we do actually have NGOs who come in. They don't always, we don't always keep the same NGOs. They rotate through. There's contracting processes. But we do actually want Aboriginal faces and Aboriginal services inside Banksia.
Commissioner Reynolds made an offer to the Commission to ensure that an Aboriginal person was in the senior management of Banksia within a relatively short period of time. Before Commissioner Mason starts negotiating with you, is there any possibility of more than one?
I think I actually missed this because I was walking down to where this hearing's being held for us. But I think we already have money for an Aboriginal services unit, which is an increase at Banksia, plus for some tendered services, some additional tendered services in the NGO sector. I think we start with one and we grow. There's a very broad agenda across the entire department around encouraging the recruitment of more Aboriginal people, but also getting them into senior positions. The department actually does pretty well. That said, we've got a long way to go to where we might like to be in Banksia, but we do pretty well. I mean, the average, I think, in the public service of Aboriginality in terms of public servants is about 3.5%. That's the target. We're at between 6 and 7%. Now, at Banksia, it's around, according to Superintendent Reid, around 10% at the moment. It's not bad. It could be better, but it's not bad. I don't think we're neglecting it, but there's always room for improvement. There's always stuff we want to fix. And that applies for the adult system as well. We haven't talked about that in my evidence today, but the reality is it's equally important that we run programs and have senior Aboriginal people in places there too.
Dr. Thomason, commissioners have other commitments. I'm conscious of the time. I wonder if I might pause my questioning and give the commissioners the opportunity to ask you any questions.
Sure.
Yes, Commissioner Mason, do you wish to negotiate?
Not on this occasion, but thank you, Dr. Thompson, for your evidence and also for your willingness to consider senior input of Aboriginal people from Western Australia. It's a huge state, but these kids in Banksia Hill come from all over the state. The wonderful thing about the Aboriginal community is our network and connection with communities right across the state. So, and I'm sure if that different approach does happen, I'm sure the Aboriginal community control sector will swing behind it in more ways, I'm sure. So thank you very much.
Thanks, Commissioner.
Thank you. Commissioner McEwen?
No, other than to say thank you for your evidence.
Yes, thank you very much, Dr. Thomason, for giving evidence today. We appreciate the assistance you've provided both in your written statement and in the oral evidence today. Thank you very much.
Thank you, Chair.
Does that conclude our...
That does conclude the evidence.
Are there any directions to be
Yes.
made?
We have directions for consideration, Chair.
I'm not sure I have a copy. Yes, well, I'm told I do.
Chair, my understanding...
Have the proposed directions been distributed to interested parties?
They have, Chair, and as far as I know, there's been no adverse feedback in the sense of somebody wanting a change.
All right, in that case, in order to save time, instead of reading out the directions, I'll initial the copy of the directions that have been provided to me on the basis that they've been provided to the represented parties, and none of the represented parties has any objection to the proposed directions. So I'll make the directions in the document that I have initialed and dated.
Chair, can I take the opportunity of thanking the witnesses, their legal representatives, those with leave to appear, commissioners and commission staff for making today happen. It's required an enormous amount of reorganisation and work because of the holiday which disrupted the Perth sittings. But on behalf of the council assisting team, can I thank everyone concerned?
Yes, thank you very much, Mr. Griffin. I echo those comments. It has taken a great deal of work to reorganise. I'm very grateful, and I'm sure Commissioners Mason and McEwen share my gratitude to the members of staff and all those who are responsible for organising the hearing. It is a very big task to reorganise even one day of a hearing that we had anticipated would take place in person in Perth. It is a tribute to the organisational skills and the dedication of everyone involved that today's hearing has been able to take place and to take place so smoothly. So I do express our gratitude for that, and I also express our appreciation to the witnesses that have given evidence today, and of course to the legal team, our counsel assisting, the Office of Solicitor assisting, for all the very great preparation they have done in order to present the evidence today and indeed during the entirety of this hearing. Thank you very much. I think that the Commission will be resuming a hearing on Monday week in Brisbane, and we shall be hearing then about experiences of people with disability in public places. Sorry? Yes, I'm told it's violence and abuse in public places. So we shall resume on Monday week in Brisbane, which is also one of these jurisdictions that has a different time zone to Sydney, but no doubt we will accommodate ourselves in due course.
The Royal Commission into Violence, Abuse, Neglect and Exploitation of People with Disability is now adjourned.